Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. The first case on for argument today is case 371, People v. Nori. Proceed, counsel.
Good morning, Your Honors. Cleo Weiss for Robert Nori. I'd like to begin with point one. We assert that the arrest of Mr. Nori in Washington State was unconstitutional and illegal also statutorily. And I'd like to begin with the NCIC alert, the computer entry that the Washington State troopers had. We submit that this computer entry was not a direction to arrest, and that's a fact that the people concede. They concede in their brief that it stopped short of directing Mr. Nori's arrest. But they rest instead upon the assertion that it was the functional equivalent of a direction to arrest. But I would ask this court to reject that contention, and it's not a functional equivalent because this was not a vague directive. It was a direction to do something else. It was a directive to stop and identify. And that's directly from the trooper's testimony. What information were you giving regarding this vehicle that was wanted? The registered owner was a possible murder suspect, and they wanted the vehicle to be stopped, identify the occupants.
So based upon that information, what were the officers supposed to do?
They were supposed to stop and identify Mr. Nori, and that actually accords exactly with what the U.S. Supreme Court has said in United States versus Hensley, which is that for these sort of teletype computer entries, the reliance on the bulletin justifies a stop to check identification, pose questions.
Part of the bulletin here involved an indication that he was a dangerous person.
A possible murder suspect.
Yes, right.
Yeah.
And so what you're saying is what the officers were required to do is stop, approach the vehicle, and engage in a conversation to identify him.
That's not what I submit, Justice Whalen. So what's interesting is the trooper
You
in this
understand
case,
my concern?
I totally do.
Yeah.
And I think what happened in this case is the trooper gets the dispatch. He identifies the red Jeep traveling down I-90. He pulls beside it, and he testifies that he actually drives his car next to the red Jeep. He looks over.
He's able to identify the physical characteristics of the driver, which match the information provided, right?
Exactly. And at that point, he hasn't stopped the vehicle, but he has identified the occupants as the suspect that's identified. There should be a call to RPD at that moment to say, okay, we identified your guy, we have your guy. What do you want us to do? And at that point, you'd have the direction to arrest, or perhaps the communication of the substantive information that leads to probable cause.
So there's some kind of process that you'd envision going forward with radio contact or some kind of telephone contact to do some type of investigation.
That's correct, because this is
As
a directive.
they're driving down the highway.
Yeah, when you don't have a directive to arrest, in this case, this Washington State trooper oversteps his authority. The inception of the arrest, there is no direction to arrest, nor is there the alternative basis would be the substantive information that would allow an arrest.
Counsel, I know you have a number of arguments, but because we're right there at that point in what's going on here, let's assume that we agree with you. It's your argument based upon the NCIC information that if in fact there is an error here and we engage in harmless error analysis, what's your argument there? Is constitutional analysis or non-constitutional analysis?
This would be a constitutional analysis under harmless error, and I think one of the key things in addressing harmless error is to look at the trial and to look at the contested issue at the trial. Mr. Nori...
In this case, Mr. Nori didn't contest the fact that
Absolutely.
he
caused the death of Miss
Right.
O'May. That's been accepted the whole
The question is mens
time.
rea.
Correct.
Now, here's where I want to ask you the question. The information, the statements that were allowed in, that are the troubling statements for you, the information that was obtained in the state of Washington, did that not help in the mens rea argument for the defense below? Relative to, I was confused, I blacked out essentially. It seemed to me that some of those statements were actually helpful as opposed to harmful. Am I wrong about that?
I mean, I think that Mr. Nori had to deal with the hand he was dealt at trial. This information was not suppressed by the trial judge. He got lemons, he had to make lemonade. So did the attorney find a way to get something out of those statements? Yes. Did he find a way to knit them into the theory of the defense? Yes. But The people rely on these statements as well because they're very incriminating. They are replayed in closing, the entire 35-minute interview. And I think that there's no way to say that there's a reasonable probability that there wouldn't have been a different result without this information coming in. And I would also note the statements, I think, are the most harmful and certainly the focus of the inquiry, but there's also some forensic evidence, clothing and other items from the car that do stem from this arrest as well.
And I interrupted the flow of your argument, and I apologize for that, but go ahead.
If there's no further questions about the direction to arrest aspect, I would move to the substantive information aspect.
Well, before you go there, just on your statement that it was, the statements were highly incriminating, if you're conceding that there was, I mean, it's essentially overwhelming evidence that he committed this murder, going back to Judge Whalen's point, doesn't this help your client? Because they're not, it really isn't more incriminating than all the other evidence, is it? I mean, it doesn't really assist that much.
I think his statements absolutely bear on his state of mind at the time. But as an example, if these statements had not been admitted, Mr. Nori might have testified at trial. There would have been different trial options if he was not stuck with this evidence coming in. And in light of the fact that he's only contesting his mens rea, what happens by not suppressing those statements is that the entire trial theory has to be built around those statements he gave during that interview.
So even though the evidence, the statements that he gave is really the only evidence that we have of recklessness as opposed to intentional conduct, what you're suggesting is that if we didn't have those, he may have done even better in terms of testifying as to his own mental state.
I think that's correct, Your Honor, and I would also say that he would also have had an option of different trial strategies if he had chosen to pursue different trial strategies without those statements coming in.
By way of example, counsel.
With those statements coming in, you have no option in this trial but to accept the fact that Mr. Nori caused Miss O'May's death. Without those statements, in theory, this could have been a whodidit trial.
Fair enough, thank you.
And I'll return just briefly to the NCIC alert. The people submit that it provides probable cause, that it substantively provides probable cause. I also asked this court to reject that. The only information is possible murder suspect. There's no basis, no underlying information for why RPD has probable cause. And I think the Bernia case is really instructive because it says you look at the information possessed by the arresting officer, we're really only looking at what's going on in the minds of the Washington State troopers, together with any other information that was communicated. And the only information that Trooper Sanger has in this case is possible murder suspect. And I think the Bernia case is also interesting because in that case there was radio transmissions going out and an officer heard some of the radio transmissions, but when he got out of his vehicle, he didn't hear a second radio transmission. And in assessing probable cause in that case, the Court of Appeals said we can only look at the radio transmissions he heard and not the information that was conveyed in the radio transmissions he didn't hear. So Supreme Court's conclusion in this case that RPD's possession of probable cause, which is absolutely conceded that RPD does have probable cause, Supreme Court concludes that that is sufficient standing alone to make this arrest legal, and we would reject that contention.
I have one more question about that, and it goes back to the presiding judge's question earlier about what the officer should have done. The other information that was indicated in the want was that the vehicle was involved in the felony. And it seems to me that your argument is that the officers should have stopped, identified, questioned, but then perhaps let the defendant go. But they also had the information that the vehicle was involved in the felony. Does that change the analysis?
It doesn't change the analysis because United States versus Hensley does give law enforcement the ability on these types of bulletins to detain briefly. So there's no problem to conduct a traffic stop or to pull him behind him at the gas station and detain him briefly while seeking additional information.
What's briefly?
I don't know that there's any case that's detained what briefly is, but we are at a level 3 DeBoer stop. It's a Terry stop. So I think there's some guidance in the Rodriguez case about canine sniffs, about what that detention is. I don't think the Supreme Court or any court has ever put a number on what briefly is.
You might argue enough time to call Rochester.
I think that would be appropriate in this case, yeah.
I understand.
Do you want to touch upon the sentence or not?
I do want to touch upon the sentence, but if your honors would allow me, I do want to touch briefly on the Extradition Act point as well, which is the second basis for why we submit that this arrest was illegal. Watson, of course, sets the constitutional floor, which is probable cause. But when states, such as Washington and New York, in fact, 49 states, minus Mississippi, have adopted the Uniform Criminal Extradition Act, and I don't think that we can ignore that. The people seem to argue that a violation of a procedural statute should not lead to suppression. But I would point out that this court in People versus Burke, just last year, suppressed on the basis of a fairly technical violation of statutes regarding which counties issue warrants. So I do think that if this court finds that there's a violation of the Extradition Act, and it's an intentional violation of the Extradition Act, that does lead to suppression in this case, particularly because it's an intentional violation where it's a tactical decision not to seek an arrest warrant. They're doing that for their advantage so that they can interrogate Mr. Nori without the right to counsel attaching. And I just don't think that we can ignore a procedural statute, particularly one where the charge rule, that a defendant or a suspect must be charged in the state requesting the arrest, that was a distinct choice when the Extradition Act was adopted, to have that rule and to have a higher standard for out-of-state arrests than for in-state arrests in that case.
We'll take a look at that, Counsel.
If I may talk briefly about the statements being involuntary, it is the people's burden to establish beyond a reasonable doubt that statements are voluntary. And one of the huge problems I have with this case is that we have an 18-hour period of time during which we have no evidence of what happened to Mr. Nori. We know how he was arrested, we know he was booked into jail as a fugitive, and we know 18 hours later RPD members arrive in Washington to interrogate him. But we have no information on what happens to him in those 18 hours. And I believe that it was incumbent upon the people to establish that he had food, that he was allowed to sleep, that he wasn't subject to coercive and psychological pressures. We have an 18-hour gap, a very big missing puzzle piece in this case that I think is crucial. We know Mr. Nori has suicidal ideations going on, that he was driving to the Pacific Ocean to commit suicide. And I think given all of the circumstances in this case, that missing 18-hour gap, and then we look at the actual interview itself, where we've got two interrogators and one jail corrections officer in a very small cell, a holding cell, sitting next to him on a wooden bench, that's kind of a coercive environment for an interview as well. And then I would ask this court to consider also that delay under Jin Cheng Lin, where they are delaying the judicial determination of probable cause in this case for one reason alone, to interrogate Mr. Nori. If your honors have no questions, I would just close briefly on the sentence. We're requesting that this court consider reducing Mr. Nori's sentence to something less than the maximum. Supreme Court's remarks at the conclusion of sentencing indicate some vindictiveness, some over-personalization of the case. So I just ask this court simply to weigh the proper factors and to consider Mr. Nori's background.
We'll take a look at that, Counsel. Thank you.
Thank you.
Good morning. I also will start with probable cause. And I think that what's missing here is the whole purpose behind the fellow officer rule. And that is so these conversations where an officer in Rochester doesn't have to detail line for line the specific basis for the determination of probable cause. And this was specifically addressed in People versus Mims. And you're looking at the collective knowledge of the police officers in this case. Defense counsel, there's no dispute that the investigator in Rochester had RPD. There's also no dispute that the trooper who arrested the defendant in Washington acted on the directive of Rochester Police Department. He would never have stopped had that information not been entered into NCIC.
But the NCIC, I mean, the argument is that the NCIC didn't contain the information for probable cause. The officer in Rochester that submitted the information that resulted in the bulletin did. Is that right?
The argument's really twofold, Your Honor. We submit that had there not been a Havelka challenge at the motion stage, that NCIC report would have been enough to sustain probable cause, but there was a Havelka challenge below. So the police officer in this case who laid out all of the probable cause, we submit was enough to establish the basis for the stop of the defendant's vehicle. And that is really what's controlling in this case. The case upon which defendant relies is Burnja. That is a footnote upon which they rely. In the initial brief filed by defendant, they rely on Mitchell. Mitchell was in sum and substance overruled by Mims. Mims came out of the same department as Mitchell. And the Mims Appellate Division decision cites Mitchell. And MIMS now stands as the Court of Appeals stating that you looked at the collective knowledge. And because we put the police officer on, both police officers on in this case, both the police officer who took action and the police officer who filed, the police agency who filed the directive for the NCIC transmission, we submit that we satisfied our burden. With regard to...
Assuming we disagree with you,
Certainly.
the harmless error analysis, you want to address that?
I would, Your Honor. The theory of the defense was not driven by the statements defendant made. The theory of the defense was driven by the fact that video footage placed him in clothing, shortly before the murder, and then the victim's blood is found, so those same pieces of clothing are found soaked in the victim's blood. So clearly, there's
A lot of evidence that he did the act.
absolutely intentional.
Well, now, when you've got these statements, my question of your opposing counsel was, does it matter that these statements appear to actually have helped the defense?
They do, and I argued that in my brief, because I think had they not helped them, defense counsel probably would have tried to redact everything with regard to defendant's psychiatric history. I think they were completely consistent. He had only one defense, and that was try to do some type of diminished capacity based upon whatever, past psychiatric history he claimed. This defense was driven by the evidence in this case. You've got, I believe, 33 wounds, both stab and cuts. No doubt he did it. Video footage has him going up, him arguing with the victim shortly before. There was overwhelming evidence of intentional murder. The only possible defense in this case was some type of diminished capacity, and I think that those statements were helpful. But I do believe that, in this case, there is that we established what was necessary for the court's reliance on the fellow officer rule for a finding of probable cause. With regard to the Uniform Extradition Act, I'm not good at acronyms, so I'll call it that, completely unpreserved. It was raised in terms of a delay in arraignment. There was never any claim that it was a fleeting reference in the reply, in the summation, I believe, that was typed up following the suppression hearing. But there was never a claim that the failure to comply with the Extradition Act in any way negated probable cause. It was the police didn't have probable cause to arrest either as a fugitive or either as murder. It was never that the police were required to proceed solely by way of the Extradition Act in order to effect the defendant's arrest. With regard to the sentence, as defense counsel acknowledges in her brief, every murder is horrendous. This victim died from blood loss which would not have sustained her life. She suffered. The victim's father found her body. The defendant took responsibility only for what he was required to take responsibility for because of the overwhelming evidence. And for his actions, he deserved the maximum sentence. It wasn't motivated by the emotions of the judge. It was motivated by the heinousness of defendant's actions. Absent any questions, I rely on my brief.
Thank you, counsel. Case 372, People versus Dorch.
Hello, can you hear me?
Yes, you're appearing by audio only, correct?
Audio only, yes, Your Honor.
Very good,
Julio
counsel.
For the appellant.
Please proceed, counsel.
Okay, may it please the court, counsel. This is an appeal by Chester Dorch. The appellant raises several arguments in the appeal, some of which singularly or alternatively cumulatively resulted in an unfair trial to the appellant. The first issue would be that we raised is whether the court properly responded to a jury readback question. And in this case,
counsel, in this particular case, your argument, if I understand it correctly, is that the court, instead of reading back both the prosecutor and the defense examination, chose to read back only the prosecutor's examination. Is that right?
That's correct, Your Honor. And on direct examination, the victim testified that the incident occurred within the vehicle and that her purse was snatched. She was assaulted. However, on cross-examination, and probably his only option is to proceed, or the main option would be to present a prior inconsistent statement in attempts to impeach the victim's testimony. So when he does that, obviously it brings the events outside of the car, because their prior inconsistent statement said, hey, listen, this happened outside of the car. So when the jury is requesting both from defense counsel and the prosecutor, I think they want both versions of the testimony rather than what happened inside of the car.
Counsel, I agree that the jury requests seem to pretty clearly request both the defense and the prosecutor's questioning. Didn't the court provide a charge or an instruction to the jury that if they wanted more, they could ask for more?
I think, yeah, they did, but I think at that point, you have to also look at the undue influence a judge has over the proceedings. I think he could have just said, hey, listen, the defense line of questioning is what the victim testified may have happened outside the car. Would you like to hear that? Rather than, hey, it's a little confusing to the jury, and they may have mistaken that, hey, listen, do you want to hear something different as well? To me, I think that he had two options. One was to read both lines of questioning, or two, specifically request, hey, jury, do you want to hear this version as well?
Counselor, can you hear me okay?
Yes.
Counselor,
can you hear me?
Okay. The people cite in their brief People versus Wilson for the concept that even if there was an error and failure to read back the cross-examination, that that the defendant in that case failed to demonstrate prejudice to him. Can you demonstrate to us any prejudice? First of all, do you agree that prejudice is part of the analysis? And secondly, if you do so agree, what prejudice did the defendant suffer here with respect to the failure to not read back the cross-examination?
Okay, so I think that failure to read back was prejudicial in that the events that the victim testified on in her inconsistent prior statement, inconsistent statement, it may not have risen to a robbery first or second. So that it was definitely prejudicial. If we're only hearing testimony that this happened this way, I think it definitely is prejudicial. I don't agree that prejudicial is required. I think that it's more of a constitutional error anyway. That, hey, listen, they wanted to hear both sides. They didn't. It sort of took the ultimate question outside of the jury's hands at that point.
Counsel, do you want to address the suppression hearing argument?
Sure. So when they arrested Dorch, they seized his vehicle and searched it. At that point, once they seized it, they possessed it. So once you possess it, I think you have an obligation to test it, especially considering the knowledge at that time by the police officers was this may have occurred within the car and all this blood was lost within the car. I think you definitely have an obligation to test the vehicle, number one. Oh, no, I'm sorry. That was for the adverse inference charge, Judge. I'm sorry.
Counselor, can you talk about defendant's standing to search the car?
Yes. That's I know that you're again, so I got confused. So the standing is that the defendant was apparently possessed the car during the assault. He was using the car during the arrest. The police were able to identify Chester Dorch as a suspect using the license plates from the vehicle. So these were all affirmed by defense counsel, and so we believe that he did have standing as a co-owner of the vehicle based on the reasonable circumstances there.
You're saying there's proof in the record he was co-owner of the vehicle. Can you cite to some part of the record that would demonstrate that?
Just the police officer's testimony that they were able to identify him through the license plates, that he possessed it at all times, that during that we can see during this that he regularly used the vehicle. I think that would give him co-ownership.
Okay.
He would have dominion and control over the vehicle. Yes.
Thank you, counsel. Anything further?
I think that's it. Well, yes, Judge. We also believe it was reversible error where the judge failed to charge a lesser included robbery third, where the evidence may have supported a robbery third rather than robbery first or second. Two versions of that. And is that, first of all, robbery third is definitely a lesser included of first and second. Is the reasonable view of the evidence that robbery third did in fact occur here? I mean, you've got two different views. One is the victim testified, hey, he snatched my wallet. And rather than her exit the vehicle and call the police, she assaulted him. And then he may have insulted her. But at that point, he may have been defending himself. I mean, that's always a possibility. Even if he wasn't defending himself, maybe he's retaliating for her assault on him. Either way, I think at that point the robbery was over. Or you could go by the first version of what she stated that, hey, listen, I went up to his vehicle, approached the driver's side window, and he snatched my wallet. And then for some reason he pulled me through and I got cut. So I think you've got a possibility that this could have been a robbery third. I don't think you can foreclose all possibilities that hey, this is either first or second. It can't be third. Yes, Your Honor.
Counsel, we'll take a look at that. Thank you.
Appreciate it. Hey, thank you.
Counsel, proceed.
Good morning, Amy Wallensack on behalf of the people. I'll plan to address the points in the order that counsel addressed them unless the court has any other questions. With respect to point one, the jury, as I recall the note, asked specifically for testimony from the victim about the time that she was inside the car on Glenwood Avenue. And I believe it's this phrase that limits what the court was responding to.
I have one question about that. So in reading the cross-examination, the first part of it is devoted to the first account of what happened, which may very well have been on Glenwood, but wouldn't have been in the car because it was this thing about going through the window, right? Yeah. So there was talk about that, and then there was an inordinate amount of cross-examination about the route they took. Mm-hmm. And I appreciate that as well. Then you get to page 380 of the record. And on page 380, defense counsel asks, you never saw anybody actually holding a knife, correct? And she says no. And then there's this discussion about digging somewhere in the center console. That's clearly going through, it's the second account, it's the second description of what happened, it's clearly on Glenwood, it's right there. That wasn't read to the jury, was it?
It was not. I acknowledge that there was no cross-examination that was read to the jury. I don't recall the specific page numbers, I apologize, but I believe the court was focused specifically, and I believe the discussion with defense counsel here in particular, everybody was focused on the part about the standing outside of the car. I don't believe that any of the attorneys recognized that particular question on cross-examination. However, I would note that in responding to the jury, the court told them, this is how we interpreted your note, and if there was something else that you were looking for, please ask another clarifying question and tell us what it was that you were looking for. The jury asked for further instructions after this one, so the jury knew how to ask the court for more information.
It's a little troubling, though, when the question is asked specifically about both questioning, both the prosecutor and the defense's questioning. In the actual note going to the judge, and the judge chooses to read just the first half of it.
I agree, but again, I think the judge was focused on the question about the specific content of that event.
Did the judge have an obligation to drill down with the jury if the judge wasn't sure what the jury wanted at that point, as opposed to simply making a decision to just read half?
Yes, and I believe that by the court, in fashioning its response here, the court was also in the position to see the jury and interpret their reaction to the readback. And if the jurors had, made some sort of facial expression or something of, no, that wasn't all, that's not what we wanted to hear, the court also did tell the jury that please ask...
Doesn't the court have a bigger obligation than trying to read facial expressions?
Yes,
If the court's not sure, if counsel have concerns, the court at that point can go back and drill down on it and ask specific questions and have the jury even rephrase the question if need be. But to simply read just half of what was asked for seems troubling.
Again, I think that the court, by telling the jury that this is what I'm going to read you, but please clarify if I have misinterpreted your note, I think that
Your
does
argument
address
is
the
that
question.
cured it.
That cured it. And also, I do note with respect to the prejudice analysis in Wilson, I do have the benefit of that case came out of Monroe County, and I was able to read the briefs. And my understanding of the facts of that case is that it's almost identical to what happened here. In Wilson, the court had given the jury an instruction and said, if I misinterpret, something to the effect of, if I misinterpreted your note, please ask for clarification. And the jury sent out several subsequent notes, but did not circle back to the initial request. And this.
But a possible distinction is, and what's troubling me the most anyways, is your reference to the case on prejudice, right?
Mm-hmm.
That's where I was focusing before.
Gotcha.
So the prejudice, to me, might be tied into the Court of Appeals case called Taylor, whereas I understand one of the faults and the prejudice may have been that the court affirmatively said there's no testimony on that subject. And here it seems that the court didn't just fail to read back, but vis-a-vis the question of prejudice, informed the jurors that there's only questions on direct examination with regards to that. So the prejudice in Taylor, as I understand it, is the purported misleading of the jury on that subject matter, that there's nothing else for you to consider, thereby questioning their memory of that. So that's the prejudice here, I think, Counselor, and would you address that for me?
Sure. With respect to the two questions that Justice Nowak pointed out from the cross-examination that relate to the time in the car, here I believe the defense was that this victim was incredible. Her initial account was that she was never inside the car. Defendant attempted to pull her inside the car after kind of flagging her down on the street. That was what defendant wanted out there in front of the jury. I don't think he was concerned with the where did the knife come from part. It was that she was never in this car to begin with, and that's why you have to discredit her account. So those questions don't really alter the defense of the case that much. They don't really give him anything that, is going towards his ultimate theory of she was never in the car in the first place. And if there are no further questions, I'll move on to point 3 in the standing issue.
Please do.
So here, defendant admitted in his motion papers that he was loaned the car. He was not the owner, and it was registered to, there was a discrepancy about whether it was his girlfriend or his wife, but I believe it was defendant's girlfriend at the time. My understanding is when the officers had the arrest warrant, were going to arrest him, they passed him on the street. Defendant saw them and sort of haphazardly parked the car at a diagonal kind of in front of the house and immediately fled the car and started trying to get into the house. He was not in the car or in the immediate vicinity of the car when he was taken into custody by the officers. He, other than saying I was a daily user of the car, did not provide any further information in his motion papers about his standing. He didn't allege how long he had been a frequent user of the car. It could have been earlier that day.
Well, it sounds to me like your counsel for the defendant is arguing ownership during the argument here. Not necessarily that he had regular use of, which we often will get cases like that, that the defendant regularly used this, took it to and from work every day, used it on the weekends. Counsel appears to be arguing that there's sufficient basis to determine ownership or co-ownership of the vehicle.
I disagree with that. I mean, I think the fact that defendant acknowledges right in his motion papers, I was loaned this car. I mean, an owner wouldn't be loaned their own car. It was undisputed that it was registered to the defendant's girlfriend. There was no evidence that he had paid for part of the car or anything like that. My understanding was that the license plate, the way that they were led to defendant was because the license plates were registered to defendant's girlfriend who resided at this address. The police knew they were looking for a male, so this most likely was not the robber. And it was through looking at the occupants of that address that they came upon defendant, and then the photo array was done, and that's how we get to him. Again, circling back to defendant's use of the car, though, there was no allegation that defendant had keys to the car, that he kept any possessions in there regularly. There's nothing in his motion papers that would suggest that he had any sort of expectation of privacy or that he could exclude other people from the car. And that's what's needed to get him standing. So the allegations of just mere use alone, there are cases that say that that's not enough. You need a privacy interest, and specifically excluding others from the car is something the court would look at quite seriously. So it's our position he didn't sufficiently allege standing and wasn't entitled to a hearing based on that alone. His motion papers outside of the standing issue really didn't raise an issue of fact challenging the search. As I read his motion papers, it was I, a non-owner of the car, did not consent to the search. And outside of that, we really don't have anything in those motion papers.
Just one aspect of the whole issue of standing, I suppose. The girlfriend, it's the people's theory that when this search of the vehicle was done, which was 12 days later, 12 days after the incident, that the knife that was actually used in the crime in this case was on the passenger seat. Mm-hmm. And when the girlfriend goes out to the car, sees it and hides it under. So first of all, the knife stayed in the car for 12 days, this car that he supposedly had no dominion or control over. But then the girlfriend, in seeing it, tries to hide it under the seat, which came up. Does that impact at all our view of standing? The fact where we can sort of get a sense of the relationship between these two folks in the car?
Well, I think that he has to exert some sort of, leaving the knife here, I think, like, in light of the lack of any other evidence, we don't know if on the day of the crime that was the only time that defendant used it and then he happened to be driving it on this day. We have no information about those 12 days in between. It's possible that he was in the car on the day of the crime and that was the next time that he was in the car, and defendant, as the person asserting this interest, would have the facts available to him to make a better case for standing. I'm sorry, did I address your question, Justice Nowak?
I think so. I'm trying to think of other things that would establish it, a gym bag in the car, something like that, but which we don't have, but it strikes me that it seems that might be part of the analysis. That's all. Thank you.
Yes, and I would also note, too, with respect to the suppression issue, the knife was recovered, but it was undisputed at trial that it tested negative for the presence of blood, and there was no DNA that was sufficient to identify any of the 3 DNA profiles. So defendant used the knife quite heavily to say, like, well, this wasn't even involved in this particular crime. It's relatively exculpatory. And then I believe, unless you would like me to address the adverse inference, I think my brief fairly lays out our position on that. With respect to the lesser included, there is no dispute that a physical injury occurred here. Looking at the the photos of the injury alone. And there's no question that anything but a dangerous instrument caused that. It's simply not possible that this was caused by a fist. I would just note that the injury and the deadly weapon can be used in the retention of the property. The testimony here established that the defendant took the wallet from the victim, and then she said something to the effect of, "Give that back." And that is when defendant slapped her in the face first, and then I believe she testified that she hit him at some point in this scuffle, and it was then that he sliced the back of her neck. There is no reasonable view of the evidence that this injury and the weapon being used occurred in the retention of the property.
I think we have that argument, counsel. Thank you.
Thank you.
Case 373, People versus Murray. Counsel, proceed.
Aaron Murray's trial was riddled with the erroneous omission of evidence and some discovery violations on top. I want to focus my comments on point 3 of the brief today. The Supreme Court has recognized that to ensure a fair trial under the Due Process Clause, you got to consider all of these errors cumulatively for the harmless error analysis. And one of the things that's interesting to me in this case is the interaction between the discovery violations and then how you can see that they become prejudicial as the trial plays out. And I'd like to start with talking about the search warrant execution plan. This is an item of discovery that was specifically requested by defense counsel prior to trial. The people say that they were unaware that anything existed that they hadn't turned over, but then after jury selection concludes, oops, the people have this search warrant operation plan. They say, we're so sorry, we didn't intend to misrepresent that this didn't exist. And this is an important document because it indicates that Mr. Murray was the target of the search warrant that was executed at a house. And in terms of, the Article 245, defense counsel was supposed to have that discovery during plea negotiations, and that type of information indicates this might be a much weaker case to take to trial. So we're kind of looking at Mr. Murray choosing to go to trial without that important information that he was actually the target. And that's pretty crucial in this case because there's a co-defendant, the cousin, who's in the house at the same time. And the obvious trial strategy here might be to say, well, it was my co-defendant's contraband, not my contraband. But when you're the target of the warrant, that argument is very much undercut. And in this trial, the fact that he is the so-called target of a search warrant for a house is irrelevant. It comes in, and it's a type of Molyneux evidence because it indicates that law enforcement has information about prior bad acts or prior information about Mr. Murray that made him that target. And I think it's acknowledged by Supreme Court that this is error because the court, of course, gives a curative instruction. So you've got that error, and I think that this error interacts with another important error, which is the police officer's testimony that Mr. Murray had a prior arrest. And these two pieces of information are particularly prejudicial, and I think synergistically prejudicial, because this is just a circumstantial evidence case about which of two adult males in the upstairs of a house has this hidden contraband that's in the laundry basket and in various drawers. And propensity evidence, two different types of propensity evidence in this circumstances.
Counsel, let me interrupt you just for a second. We've got two males. When the warrant's executed, who's coming through the door, which I don't think was locked. I think they were able to just open it and enter. The two males are coming down the stairs from the upstairs, correct?
When the officers enter, Mr. Murray's already come down the stairs and he's in the process of getting on the ground, and the cousin, Duan Gross, is behind him by a minute or so.
My question is, can both of those, the defendant and the co-defendant, constructively possess the drug that were subsequently found with the search warrant upstairs?
Your Honor, they absolutely can jointly and constructively possess them.
So it's not one or the other?
It's not one or the other, but when you're at trial and it's not a joint trial, Mr. Murray's at trial by himself, the co-defendant is not there, and I think this type of propensity evidence tips the scales, and it kind of makes counsel's argument much harder, because it kind of tends to point that Mr. Murray's a bad guy and he's the target of this warrant, and that's difficult information.
During trial, I'm focusing on the phone number testimony and the questioning, and it seemed pretty clear that, at least it struck me as kind of an inadvertent question and answer response that sometimes happens at trial all the time, and it resulted in an objection. I think the court reacted appropriately with respect to that, and wasn't there even a direction ultimately concerning the court to ignore that information? Doesn't that, and I know you're talking about the synergy between the two, and it's a buildup of a number of errors that result in the problem for your client. But that problem by itself is not uncommon in a trial, and it's a problem that was cured, I think, in this case by the judge. Wouldn't you agree?
I wouldn't agree that the curative instruction, though it was given with respect to both of these errors, this is one of these cases where I don't think the bell can be unrung. And to me, the reason for that is that if this was a more complex trial or with stronger trial evidence, these two errors standing alone could be considered harmless. But in this trial, it is such a short, small trial with a discrete issue in it, and it's purely circumstantial evidence. And I think in the context of this trial, with its kind of thin evidence, these two errors, both being propensity evidence errors, cannot be considered harmless. And I would, in point 3 of the brief, I'm also asking this court, those are the two strongest errors, I think, that occurred, but of course they weren't the only errors, and I'm asking this court to consider everything in the totality. And just briefly on those other errors, I believe that Supreme Court erred in relying on defense counsel's expertise to cure the people's problems. Defense counsel's expertise does not lift the people out of non-compliance with statutory requirements, and I think that was an inappropriate factor for the court to look at. Unless this court has any other questions, we would ask this court to reverse for a new trial because this was not harmless error.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Marty McCarthy for the people. When you look at I'll start with the operation plan. Yeah, that should have been turned over. But at trial, the issue becomes not whether, counsel should have struck the certificate of compliance. The issue is did counsel receive it with enough time to make use of it? Did counsel demonstrate prejudice as a result of receiving it late? There was no demonstration of prejudice here. In receiving
What do you say about your opponent's argument that had that information been provided in a timely fashion, it would have allowed the defendant an opportunity to make some judgment calls on whether or not to go to trial on the case? And is that a factor that we ought to be considering?
That's a different section of the CPL that relates to the timeliness of turning information over in order to make a decision about a plea. But there's no indication in this record that we have that receiving that document would have made the defendant more likely to plead guilty in this case. So his co-defendant did plead guilty. And the interesting thing about his co-defendant, and you typically don't see this, the co-defendant got a greater sentence after pleading guilty than this defendant did for going to trial. The judge was favorably disposed to as you can see in the sentencing. The judge is favorably disposed to this defendant. The prosecutor also appears to be favorably disposed to this defendant. Had the defendant said, hey, well, this is different, this would have changed my outlook on life, I do want to plead guilty, I have every reason to believe that the prosecutor would have plead guilty instead of going to trial. So if you want to consider that, to the extent you can based on this record, I would ask you to consider it that way. That nothing was stopping him from pleading guilty at that point. He just chose not to do it. The document, there's no dispute that the document was turned over, and there's no argument that I can see that counsel...
So you're saying even at the time of trial, there may have been a possibility of a plea once the document was turned over?
It is not our, and again, this is not...
We don't know that from the record before.
No, and I'll just say that it is not our policy to say, hey, once trial goes, we're not going to offer plea bargains. That is not how we prosecute in Monroe County. So, especially when you consider, as I mentioned before, the actual favorable disposition that the parties had towards this defendant. So I can't imagine scenarios like, oh, it's too late. Sorry, you're not going to be able to do that. So the extent you can consider it on this record, I'd ask you to consider it as there's not enough evidence that would have impacted his ability to plead guilty. And there's no evidence in this record to show that counsel was actually prejudiced by the late receipt of this document. And with respect to the other, the two other errors that counsel claims sort of act in synergy with this search warrant issue, just as well, and you pointed out, there was a curative instruction given for both. Had there not been a curative instruction, I would concede that this would be a tougher case to talk about in terms of cumulative error, but the errors were remedied.
But you'd agree, I think, that every case kind of stands on its own. And we have many cases where these errors standing alone are understandable and they're cured. But there are cases where the errors are cumulative.
Yes.
And as your opponent pointed out, the synergy of all those, depending on the type of the error, sometimes result in a prejudice that it can't be overcome with a charge, the unringing of the bell argument.
And typically, when you look at prejudice, you look at what if any remedy occurred. And if there was no remedy occurred, obviously the scales get heavier when you talk about the cumulative error. But when you consider, one, the nature of the error, I will concede that there are times where it would appear from a record that a prosecutor is attempting to evade the ruling of a court to get information out some other way. That's not what happened here with that question regarding the phone number. The purpose of that question was simply to link up the phone that they found in the bedroom to this defendant. And the way they were going to do that was the fact that they provided that number. I don't think your opponent's
arguing that it was an intentional effort by the prosecutor.
And I don't think they're arguing that either. And I think it's important to note that had this been intentional, then that would factor heavier in sort of a prejudice argument than the unintentional error. And I think the unintentional error was properly remedied by the fact that the court gave the curative that it did. Is there no other questions?
No questions, counsel?
Thank you.
Thank you. Case 374 and 375. I'm sorry? On the video. Oh, in person? Oh, my apologies. Oh, yeah. No, you're exactly right. Thank you. I'm going to deem that case submitted. Thank you, Jeff. Case 376, Hayes versus Rich. I'm waiting for the video to come. Counsel, can I assume, just for identification purposes, both counsel are appearing here, but one's arguing? Is that right?
Yes, I'm the only one arguing.
Very good,
Yes.
thank you.
My name's Cam Meisner. I'm a law student at Cornell, authorized to practice under the supervision of attorney Christina Knightsey. May it please the court, this court should reverse the Supreme Court's holding that the anti-SLAPP law does not apply to this defamation suit in which plaintiff Michael Hayes seeks recovery for statements made by defendants on Facebook alleging that Hayes committed sexual misconduct and cyber harassment. In addition, this court should hold that because Hayes failed the pleading specificity requirements of 3016A of the CPLR, this claim necessarily lacks a substantial basis in law, and the defendants are therefore entitled to a mandatory award of costs and fees.
Counsel, let me ask a question about this, and maybe it's, I just don't understand it, so help me out here. The pleadings itself didn't contain the specific information,
That's right.
right?
That's right.
And that was that's a failure of the pleading itself, and the case was thrown out based on that.
Right.
Without the specific information, how do we do the analysis under 3211G?
So the substantial basis in law standard under 3211G is a higher burden than the typical motion to dismiss vehicle, 3211A7. And as the First Department has held a couple of times and we think is absolutely correct, a 3211A7 dismissal means that a fortiori, a 3211G substantial basis in law is not satisfied. And so the question is if the anti-SLAPP law applies, or that is the question, whether the anti-SLAPP law applies, and we think that if it does, the dismissal under 3211A7.
How do we know from the record before us that the information communicated through Facebook was communicated, because as I understand it, Facebook, I'm not on Facebook, but as I understand it, Facebook has a couple of different ways of communicating. Some are a public communication, some can be a group communication, and some can be a one-on-one communication. How do we know from the record before us that these communications were in any one of those three possible ways of communicating? And if so, does it matter for the purpose of the analysis?
So to the extent that the pleadings give us the requisite information, which they are deficient because they didn't plead the specific words, but they're referred to as Facebook posts, which we understand to mean publicly available posts, and that's what we understand these were.
Isn't that speculation?
To the extent that the record reflects what they are, they're Facebook posts. And
if I'm on Facebook and I have a direct communication with somebody else who's on Facebook, you're saying that that is not deemed a post?
so I think that would be correct as just the traditional understanding of what a post is. But I would remind this court that
Remember, there's no traditional understanding here, right?
in any event, Hayes didn't challenge below that these were posted on a public forum. And so the public forum analysis is a different analysis than whether the subject matter is one of public interest. And so really the question is just about whether the subject matter is public interest. Hayes never really contended that these weren't publicly available posts. And the question whether something's a matter of public interest, the statute defines that as any subject other than a purely private matter. The case law, as far as we can tell, is exclusive, that allegations of sexual misconduct, which the great majority of the statements in this case were, are connected to matters of public interest.
You'd agree if person A communicates on Facebook with only person B and makes these same kind of allegations, and we're kind of speculating as to what the allegations are because we don't know what they are, but of a sexual nature and accusatory of conduct, bad conduct, that wouldn't fall under the SLAPP law,
Not
correct?
necessarily. So there's the option under the SLAPP law that there is public forum plus public interest. But there's also a catch-all provision under the anti-SLAPP law, which hasn't been briefed here because Hayes never raised it. But it says that as long as the speakers are pursuing their constitutional right to free speech and speaking on a matter of public interest, then the SLAPP law still covers the statements. And so it's hard to tell exactly from the statute, and it's not an issue here, whether the public forum question really is a requirement for a statement in order for the anti-SLAPP law to cover it. But again, these are described as Facebook posts, and so we think that these were in public forum in any event. The question...
Counsel, did the affidavits that were submitted in support of the motion to dismiss, and 6 or 7 affidavits, did they make it clear what the posts were about?
They weren't exactly clear because the defendants themselves, I think the record reflects, weren't 100% certain what exactly the plaintiff was referring to. Our understanding is that there were a lot of Facebook posts, and we think that's the problem with the 3016A deficiency. There's the fact that they probably didn't get the full notice they were entitled to, and the fact that without the pleading specificity, it's really impossible to do a full defamation case analysis because it's really a very context-specific inquiry into what the statements can actually be construed to say. And so to the extent that the affidavits reflect uncertainty about the statements themselves, I think that's just a result of the 3016A deficiency.
The case law is clear that even if this is a private group, that can still be a matter of public interest.
That's right.
Correct. And it's only possible that if it's purely private, what's your position on that? Because we don't really know for sure from this record about who was being contacted in this.
So I would distinguish between purely private communications and what the anti-SLAPP law says we should be concerned about, which is whether the subject matter of the statement is purely private. And so the question should be whether the subject matter would be of interest to the public or only to purely private individuals. And here, the allegations overwhelmingly are allegations of sexual misconduct in the music industry. Again, the case law is clear that allegations of sexual misconduct have been held to be matters of public interest. I think the Me Too movement has placed especially the experiences of sexual assault survivors in the entertainment industry squarely in the public conversation. And so we think that these allegations of sexual misconduct are indisputably matters of public interest.
Right, no matter who's contacted, whether it's only one person or a small group or a medium group or the public at large.
That's right. And the Supreme Court seemed to suggest that it did matter who the parties were making the statements, comparing to Coleman against Grand, where the parties there were in a relationship. And the court said that the parties here were not in a relationship, and so it was a purely private matter. But the statute itself doesn't make a distinction between speakers. It makes a distinction between subject matter, as Your Honor observed. In addition, the Supreme Court focused on the word gossip, which appears in some of the affidavits and appears in the First Department's aristocrat decision. As we explained in the brief, we don't think that what the statements were could be described as mere gossip. But we hope that this court will disavow use of the word gossip in the inquiry. Gossip really conveys an image of two people whispering in a hallway about something, but that doesn't tell us what exactly those two people are speaking about, which again is the inquiry under the anti-SLAPP law. And so to the extent that gossip is ever a helpful term in defamation law, it's not helpful in determining whether the anti-SLAPP law itself applies. And so because the anti-SLAPP law applies here, Hayes has the burden of demonstrating a substantial basis in law. The Supreme Court observed that the allegedly defamatory statements in the pleadings were only paraphrased, and so he didn't meet the 3016A deficiency. We've also submitted that Hayes failed to plead adequately the elements of a defamation claim. The most obvious one is actual malice. Actual malice means, of course, subjective doubt on the part of the speaker about whether their statement was true or not. We think the record makes perfectly clear that the defendants, if anything, absolutely believed that what they were saying was true. On the first page of Hayes' brief below, he says, I deny that I did these things, and the only proof that the defendants have of it is that they believe it to be so. So we think even Hayes here understood that the defendants absolutely believed that what they were saying was true. Hayes has said that the defendants failed to verify with him before publishing. That, the law is clear, is not actual malice. And Hayes has not otherwise established why any of the sources from which the defendants learned of these allegations were not credible. We have in the record affidavits from 3 individuals standing by these allegations under penalty of perjury. And so we think there's no basis to conclude that the defendants didn't believe what they were saying, which is an independent basis to find that Hayes did not establish a substantial basis in law, and why the defendants are entitled to an award of costs and fees. If there are no further questions, Your Honors, we hope that this court will give effect to the clear purpose of the anti-SLAPP law. The defendants to insubstantial defamation claims shall not have to bear the financial burden. Thank you.
Thank you, Counsel. I am going to recall case 374-375. Counsel Forrest apparently was present and misunderstood my calling of the case, so we'll go forward.
I didn't have the number, yes. Kelly Forrest, attorney for the child. I understand that the appellant did submit her brief. I just wanted to appear in case the court had any questions for me, and also provide a brief update that Mr. Boyden remains at Hudson, which is about 4 hours away from where the child now resides. And I think that's an important factor for the court to consider in the request.
Thank you, Counsel.
Thank
you. Case 378, Jacko versus TJM Syracuse LLC.
Good morning, Your Honors.
Oh, one second, let's just make sure your opponent is on here. Mr. Murphy, can you hear us?
Yes, Your Honor, thank you.
Very good. All right, proceed, Counsel. Thank you.
Good morning, Your Honors. Adam Mastrolio on behalf of the appellant, TJM Syracuse. There's a threshold question that this court has to address, and that is whether or not the hospitality wage order creates a strict liability formula for plaintiffs to establish liability under Labor Law 196D, or whether the true inquiry is if a reasonable customer would understand that the service charge in question was a gratuity or not. Courts in this state, the appellate courts that have looked at the issue, have held that the hospitality wage order does not create a strict liability standard. Both the Ahmed Court and the Button Court, which are the first department, say that while relevant, the fact that a banquet provider does not include specific language or in a specific font size is not dispositive. And I think what happened in the lower court is the judge found that the hospitality wage order created this strict liability formula. And that's not what the law is, and that's not what the law should be. If you read the cases, the relevant inquiry is whether or not this reasonable customer would understand the service charge to be a gratuity.
If we agree with you, in this case we have 3 documents. Only one of the 3 includes the language. It's what the judge used the phrase buried on page 2, paragraph 3. The question I have, though, is pertaining to the other 2 documents. The other 2 documents seem to, not only do they not mention it, they almost seem to indicate that it's a true gratuity. So here we have a contradictory. How's the reasonable customer supposed to figure out, well, I'm going to trust the document 1, but not documents 2 and 3?
So first of all, document 1 clearly says that 100% of the service charge is retained by the hotel. So that's number 1. If you look at the other 2...
For what purposes does that document say it's being retained for the hotel?
To pay... I forget the exact language, Your Honor, that's in the contract.
But isn't it fair to say even in that document, the language does seem to indicate that it's in the nature of a gratuity for enhancing the performance of the staff that is going to service the person that's using the banquet facility? Now, admittedly, that staff would include more than just the wait staff, right? So I see that part of the argument. But it does seem, I think there's a fair argument that even in that document, it could be read in the nature of a gratuity by a reasonable customer.
Well, as explained in the brief and in the papers, the hotel made a decision about how it was going to pay banquet servers. Do we go with the tipped wage, pay a significantly lower wage, take the credit for a tip, or do we pay the elevated wage? The language in the contract is simply explaining that a portion of the service charge will be going to people who are providing service as part of the banquet, not necessarily including only servers, as Your Honor mentioned. But to get back to Judge Norrick's question about the second and third document. So if you look at that second and third document, the service charge is taxed. And that doesn't happen if it is a gratuity. Anyone who's been to a restaurant gets the bill, and the bill has the food charge, the taxes, and then if you want, you can add a gratuity on top of it. So it's common understanding that if this was a gratuity, it would be after tax, not taxed. And that's something that is also explained in the contract document as well. Your Honor, we'd also point to the fact that customers can leave tips if they want. So the plaintiff acknowledged that from time to time, banquet event customers provided tips, which she received. That's more evidence that the reasonable customer understood this wasn't necessarily a gratuity. Finally, there's no evidence in the record that...
Is it fair, just to finish that point, is it fair to say that because, and I think the record reveals that on occasion, there was an additional gratuity forwarded. Should that, on occasion, that customer, the one who does provide the extra gratuity, that's the person that we should look to as the reasonable customer, not the many other customers that come through and do not provide the gratuity? Do you understand my question?
I do, and I wouldn't say it's an extra gratuity. I would say that when they leave it, it is a gratuity.
So all the other people using the facility that do not give the gratuity, they just chose not to give a gratuity?
Correct.
And so the reasonable person using a banquet facility who had wait staff taking care of their party at the banquet facility, in almost all instances other than a few rare occasions, all those customers, which were reasonable customers, just chose not to give a gratuity to the wait staff.
Certainly.
That's your argument?
Yes, Your Honor, and remember that just because you have a banquet event or an event that is that uses this contract, doesn't mean you have food and beverage. So you may not have any food and beverage at all, have an event, and you're still paying the service charge because it's not a gratuity. It is a service charge as outlined in the contract. The other thing, Your Honor, is that there's no evidence in the record of any customer that's been confused. I know that plaintiff's counsel downplays that argument, but I think it's persuasive here. Without an actual customer who's been confused, it's difficult to say, as a matter of law, that a reasonable customer wouldn't understand this and would be confused.
But counsel, aren't you kind of flipping the argument here? Isn't the burden on you, by clear and convincing evidence, just not by a preponderance, to show that this money was not a gratuity to the server? And that's the regulation, that's the case law.
Well, that gets to whether or not the regulation creates a strict liability formula. I completely understand your point, Judge Greenwood, but this is a motion for summary judgment that was granted on behalf of the plaintiff. So the judge found, as a matter of law, that a reasonable customer would necessarily be confused by the facts here. And I don't think there's any case that's been cited, it's certainly not at the appellate level, by the plaintiffs where that's been the case. The cases cited by the plaintiff, including the Mayor case and the Membreeves case, don't provide us with information about what was in the contract. There, it could have been just, here's the service charge, you, the customer, has to pay it. Here we have more than that. And what I'm getting at is, as a matter of law, this court shouldn't be granting summary judgment to a plaintiff finding that a reasonable customer would necessarily be confused where the contract says that 100% of the service charge will be retained by the hotel.
So you're saying let the finder of fact.
Exactly, Your Honor. That's correct.
Anything further?
No, Your Honor.
Thank you, counsel. Ms. Murphy?
Thank you, Your Honors. May it please the court. James Emmett Murphy from Virginia and Ambinder for the plaintiff. I want to clarify a few things that were stated during the previous argument just now that aren't consistent with the record here. Number one, as was stated, the disclaimer itself that is on page 2 of the 4-page contract that doesn't require any signature or any initialing on it that a client has actually read it, the specific language is to ensure the superior service of the Crown Plaza Syracuse team, a 22% service charge will be added to all room setup, food and beverage, and audiovisual costs, 100% of which will be maintained by the hotel to offset the labor and benefit costs for our associates serving your group. Now, the court noted that that language about offsetting labor and benefit costs very well could mean that these are funds that are going towards these workers to cover their wages and benefits. So had the defendants, for example, taken a tip credit against these workers' wages, provided this service charge to them as in the form of gratuity, and offset their wage obligations by taking a tip credit, that would be consistent with the language that's in this disclaimer. They did not do so. Obviously, they retained all of it. And again, most importantly, this is buried. This really is buried in this contract here. Under a paragraph titled Function Information of Agenda, Event and Agenda. There's no reason that a reasonable customer would ever look to this and say, oh, I understand this means that the service charge I'm being charged is not a gratuity. More importantly, where the disclaimer does not appear on the menu listing prices and on the total cost sheet, there is no disclaimer, and contrary to what the defendants say, it doesn't say that there will be sales tax paid on that gratuity. It says, and this is from page 169 and 170 of the record, all prices are subject to a 22% service charge and state and local taxes. It doesn't say that the service charge will be subject to state and local taxes. On page 170, first it lists billing, 8% tax, and then underneath that, 22% service charge. Wholly aside from the fact that it's mere speculation to assume that a reasonable customer would understand that a gratuity would not be taxed. There's no basis in the record for that assumption, for defendants to say that a reasonable customer would obviously know that. All of that aside, every case that has addressed the hospitality industry wage order since this was implemented in 2011, one exception, has said that the terms of the hospitality industry wage order, 12 NYC RR sections 146, 2.18 and 2.9 are mandatory. That the Court of Appeals in Samiento versus World Yacht said that a reasonable customer standard is what should be used in determining whether a charge is a gratuity. And the Department of Labor established these provisions to say, here's what a reasonable customer standard looks like. And it's beyond dispute that the provisions of section 2.19C requiring that the disclaimer be on the documents listing the prices where this customer has to sign for the event, there is no disclaimer here.
But counsel, would you agree that you could come up with a hypothetical case where the regulation wasn't followed precisely in terms of every document, the font wasn't correct, the font was 11 point instead of 12 point, something like that. But because of signage or other communication, overwhelmingly, you'd look and say, well, gee, anybody would know, yeah, this is not a gratuity. This is, repeated over and over again. But that's not what we have here, is it?
No, that's not the case we have here. That was the case in Button, which is one of the cases that defendants rely upon, where they didn't comply with the 12-point font requirement, but they complied with everything else. And they had proper disclaimers, and they had everything that they would need to show that, yes, a reasonable customer, under all of these circumstances, would say, this isn't a gratuity. The only thing that they didn't comply with in Button was the font size requirement. In that case, they said, well, the employer is not entitled to summary judgment, but it's a question of fact that can go to a jury.
Mr. Murphy, let me ask you this, counsel. The fact that a couple of the documents indicate that it was being taxed, right? Your opponent argues. Is that enough of a question to kick this to a jury to determine?
Not at all. This was an issue that came up over and over and over again with the state legislature in 2011, 12, and 13, when there were attempts by catering halls to get out of this kind of liability that was imposed by the Court of Appeals decision in World Gap, where they said that as long as you're paying tax on a gratuity, then that means that it's not a tax on a service charge, then that makes it not a gratuity. And under those circumstances, then a banquet hall is allowed to retain them. That's the only time in those failed bills, none of which passed. That's the only source of any kind of type at all that would say that the taxation of a service charge has anything to do with whether it constitutes a gratuity or not. There's no anything in the record here that would establish that a reasonable customer would have any idea whether taxing a mandatory service charge makes it a gratuity or not. Plenty of regular restaurants that are not banquet halls have mandatory gratuities for parties of 8 or more. Whether that's taxed or not, there's no case law, there's no statute, there's no regulation anywhere that would say that a reasonable customer would have any idea whether what the taxation treatment of a mandatory service charge is and whether that has any implication on whether it's gratuity or not.
I think I have your argument, counsel. Anything further?
Yeah, I just want to touch on the other issue that was raised about the offset that the defendants are claiming that they're entitled to against the for retroactively taking a tip credit, basically. There's no evidence in the record whatsoever that the defendants ever had any intention of taking a tip credit, or that they would have taken a tip credit had they paid these service charges as gratuities as they should have. On the certain limited occasions when tips were paid, and there are pay stubs to this effect on the record on pages 98 and 99, the defendants didn't take a tip credit in those instances when workers got tips. The defendants paid above the minimum wage rate. They didn't pay the flat minimum wage rate. So there's no evidence anywhere that they ever had any intention of saying, when you get tips, we want to take a tip credit for it. And beyond that, there's a comprehensive regulatory scheme that must be followed, mandatory, for an employer to take a tip credit. And that has to be done before employment starts. It's all in the papers. And any part of that process that's not followed by an employer denies them the ability to take a tip credit. And here, the defendants admittedly did none of that. What they're saying is, oh, in the event that we have to pay gratuities, not only are we now going to say that we would have taken a tip credit, even though our actions at the time showed that we had no intention of taking a tip credit, but also we shouldn't have to comply with the comprehensive regulatory scheme that normally you have to do to take a tip credit just because. And they provide absolutely no authority whatsoever, with the
Counsel, you
exception
should,
of
counsel,
the decision that said maybe that could happen.
counsel, we have that argument. You should begin to wrap up.
Okay, I have nothing further. Thank you so much.
Thank you, counsel.
Thank you.
Case 379, County of Orleans versus Genesee County IDA. Proceed, counsel.
Good morning. May it please the court. Alex Eaton from Lippis Mathias on behalf of petitioner Orleans County. From a mile high, I think in this case, what it really boils down to is that Orleans County is asking this court, just like we asked the Supreme Court, to uphold the general municipal law and the eminent domain procedure law as the legislature intended them to be interpreted. The respondents are effectively asking this court to orchestrate what would potentially be one of the largest, if not the largest, expansions of IDA authority in the history of New York State with any one judicial decision. Before I get into the merits of the petition, since there was no reply brief in this proceeding, I would like to briefly address 2 points raised by respondents in their brief. First being that Orleans County missed the statute of limitations in this matter. Orleans County had no issues with the statute of limitations. If your honors refer to respondent's brief, it references that certain documents were stamped in the NICEF system the day after the statute ran, that being November 21st. The reason for that is there is no tab on the NICEF site to initiate an eminent domain procedure challenge. I had emailed the documents to the 4th Department as a safeguard. My co-counsel, Ms. Persico, had a conversation after business hours with court staff. They instructed her to just upload the documents to the portal under a different type of proceeding. I have a certificate of filing from that day I'm happy to share with the court, either on paper or...
Are you saying that court staff communicated that emailing those documents was the equivalent of filing?
No, Your Honor. I had a miscommunication with court staff earlier in the day. I had sent them to the court via email, but all of the documents were within the NICEF system by midnight after Ms. Persico rectified that issue.
It seems from the record that the notice of petition was in the system, but the petition itself was not in the system till the next day.
That's not the case, Judge. And the certificate of filing will show that there's 3 documents in the system on the 21st, being the notice, the petition, and the demand to file the record. I think if you're looking at the stamps or the docket itself, the November 22nd stamps would be attributable to court staff going in the next day and manually building the docket so that it would reflect this is an EDPL 207 challenge and not some other type of proceeding as we filed under to just satisfy the requirement that the documents were within the system. Regarding the issue of whether Orleans County has standing in this matter, I think it's unambiguously clear that the county does have standing as a condemnee. We acknowledge that in order to have standing against a determination reached pursuant to EDPL 204, you have to be a condemnee. The EDPL section 103C defines condemnee as the holder of any right, title, interest, lien, charge, or encumbrance in real property subject to an acquisition or proposed acquisition. In this case, Orleans County does have duly recorded easements over both of the parcels we're challenging the condemnation of. That clearly satisfies one, if not several of those. It's certainly a right or interest in the property. Respondents argue that it functions more as a non-use restrictive covenant than an easement itself. I would disagree with the analysis there, but I think that still satisfies the requirement that it's an encumbrance. I think more importantly, too, the proposed uses of the easements the respondents seek to take by eminent domain are in direct contradiction to the stated purpose of the easements recorded by Orleans County. So by virtue of having the conflicting uses of those easements and duly recorded rights recorded in the same way as all of VCEDC's easements in Orleans County, I think that standing is something of a non-issue in this matter. Moving on to the actual merits of the petition, I think the biggest issue here is that this case is subject to 207C2, that the condemnor lacks the authority or jurisdiction to reach this decision. I think it's clear from the record, as is reflected in the petition, our brief, several documents in the record, that Stamp Sewer Works is the condemnor in name only. They're acting as a proxy for GCEDC, who is financing, driving, contracting for all of these proceedings and the accompanying force main. Yes, Stamp Sewer Works is a transportation corporation, does have eminent domain authority in the jurisdictions that it has consent to be in, but the real issue is that the force main is contiguous to the Stamp project. It runs from the Stamp site, proposed northerly 9.5 miles, emptying into Oak Orchard Creek in Orleans County. The respondents have said that the force main is crucial to the Stamp site coming to fruition as a development project. Given the geographical location and the inseparable nexus between the force main and the viability of the Stamp site, I think it has to be considered part of the Stamp project, of which GCEDC, not Stamp Sewer Works, is the lead agency. Now, the specific issue here is that General Municipal Law 854-4 prohibits an IDA from funding or assisting with a project outside of its jurisdiction, absent consent of the jurisdiction it seeks to enter. The legislative intent here is abundantly clear. This goes back to the most recent amendment of that statute, which was 1976. If the court refers to the bill jacket of that statute, it's clear that IDAs, yes, can leave their jurisdictional borders, but consent is absolutely essential, and the consent has to come from the legislative body. The Orleans County Legislature has never consented to this. The closest thing to consent on the part of Orleans County comes from a health department resolution signed off on by the joint health department between Genesee and Orleans County. Now, the health department executive is certainly not a legislator. He's not the elected official who speaks for the citizens of Orleans County. And we know that the respondents know what the proper vehicle for this is, because when they needed the approval of the town of Shelby, which they got, they went to the town board and had a resolution passed saying, yes, this is okay in this jurisdiction. But the statute's clear that you need the permission of all jurisdictions that you wish to enter. That goes up to the county level. Orleans County hasn't agreed to it.
I think we understand that argument, counsel.
So the real issue here is the funding of the pipeline. Stamp Sewer Works hasn't paid, as far as we can tell from the public filings, for a dime of this. There's one publicly available balance sheet for Stamp Sewer Works dating back to last March. They report less than $25,000 in cash holdings, no other assets, no liabilities. Just from a perspective of attorney's fees or even the development, that can't pay for these proceedings or even maybe 100 yards of the pipeline itself. GCEDC has the engagement with Phillips Lytle, who's still their counsel. Phillips Lytle represented them at the eminent domain public hearing. They noticed the eminent domain public hearing and were compensated for it pursuant to an engagement letter between Phillips Lytle and GCEDC. Stamp Sewer Works had no attorneys in 2023. If the bulk of the costs associated with condemning the property are attorney's fees, I don't see how there can be an argument made that Stamp Sewer Works is truly the entity condemning the properties when they don't even have attorneys, and the attorneys purportedly working on their behalf are being compensated by a parent entity. I think it's more telling, too, that at the eminent domain public hearing, no one who's a board member or officer of Stamp Sewer Works spoke. The only person related to the development outside of the private sector respondents was Mark Massey, who introduced himself as the vice president of GCEDC. So Stamp Sewer Works is purportedly driving this project, but no one can show up to the eminent domain hearing, and their parent entities, vice president is speaking on their behalf.
We understand, counsel.
Yep.
You should begin to start wrapping up.
Okay. So just to touch briefly on two other points here, the public use or benefit, I think it's a tenuous argument here because we're looking at north of $160,000 per job created. We haven't been able to find on record any New York State spending program or project that spent more per job created at this point. And one of the two tenants, by their own admissions, may not be financially solvent by the end of 2024. Further, the public simply opposes this project. If you look at the administrative record, starting on page 996,
A large majority of the letters coming in, 20-to-1 ratio, I think it was, are opposed to the project.
Yep, exactly. Can I address one more brief
Sure.
point on the issue of authority or jurisdiction? I know that the respondents rely heavily on the Bowers case throughout their brief, saying that this court doesn't have the proper authority, this isn't the procedural vehicle to make this argument. I'm aware that this court issued the Bowers decision after I'd filed my brief, before the respondents filed theirs. But I don't think that Bowers is in opposition to our position here. What this court found on remand was that the anti-pirating statute at issue and whether the parking lot in that case was for a legitimate commercial purpose, that's outside the scope of EDPL 207. The issue of authority and jurisdiction and the other three issues that we've briefed fits squarely within each of the subsections of 207C. I think respondents are correct that the proper vehicle for something like that would be in Article 78. The issue here is we do have another underlying Article 78 as well, which this court will hear shortly on appeal from that decision, but Bowers does not speak to what's happening here, where there's a clear argument about jurisdiction and authority, and that wasn't an issue in the Bowers case.
We'll take a look at that, counsel.
If there are no further questions, I'll yield.
No questions, counsel. Thank you.
Thank you.
Morning, may it please the court. Craig Leslie from Phillips Lytle. On behalf of the Stamp respondents, I have my co-counsel Matt Fitzgerald with me here today, but I'll be arguing, Your Honor.
Very good.
So I think a couple of things. One, to deal with the procedural issue with respect to the statute of limitations, the court will take into account whatever is in the system. We're not privy to that. We certainly don't have visibility other than the fact that we know that there was a notice of petition filed on ECF. No petition that we can tell was filed on the day that it was due. So if there was something uploaded or there were ex parte communications with court staff that we weren't parties to, we can't speak to those. What we can speak to is the fact that everything that we've seen indicates it was a day late in filing of the petition. The petition is
Mr.
what
Levy,
matters.
Just a quick thought on that.
Yes, Your Honor.
Was your client or clients served with any petition other than the one that's reflected as having been filed on November 22?
No, Your Honor. No, but we weren't served timely with it. But in any event,
And
the day late case is, yes, Your Honor.
According to the record, this notice of petition was filed at 11:55 PM.
Yes, Your Honor.
So we're supposed to believe in the last 5 minutes, everything was corrected before midnight.
I mean, effectively
There's
that.
nothing in the record.
Right, right. The record does not contain any indication that was the case. They somehow managed to file the notice of petition 5 minutes before midnight. That does not commence the proceeding. The case law is pretty clear on that. The notice of petition is not sufficient. That's the matter of 680 Realty Partners we cite in our brief, and the court can't extend it. So unfortunate for the county and is our position, but you have to be aware of these things in terms of when they have to be filed. However, we'll defer to the court's evaluation of what's in the system since we don't have visibility to that. Turning to the merits, there's two things. One, this court is well aware that its scope of review is limited when there is a challenge to an EDPL proceeding. The reliance on Bowers, and the point of Bowers is, as my opposing counsel has conceded, there is a separate Article 78 proceeding that goes to who's funding this and does it make a difference. And frankly, it's a misnomer to say that GCEDC is funding it. The record is clear that what's happening here is Empire State Development, it's a state priority project, has invested funds in STAMP. It has delegated the authority of dispersing those funds from an escrow account held by GCEDC to GCEDC. So the funds that are being paid out have been designated by Empire State Development not only for STAMP, but particularly in this instance for the sewer project, the Force Main project. So what GCEDC is doing is holding those funds in escrow. It cannot spend them at its discretion. There's a recapture provision. There are grant disbursement agreements. That's all in the record. They are being expended on behalf of STAMP, so STAMP Sewer Works particularly. So the fact that it's not passing into STAMP's balance sheet before it's spent is frankly irrelevant and immaterial to the question of whether STAMP Sewer Works has the authority to condemn. The issues about its...
What about the argument that at the hearing, nobody from STAMP showed up?
The requirement, Justice Whalen, is that STAMP Sewer Works hold a hearing, and by the way, their counsel did. Mr. Fitzgerald spoke at that hearing on behalf of STAMP Sewer Works. There's not a requirement that STAMP Sewer Works produce an officer to produce testimony. The purpose of the public hearing is to take public comment and testimony. So the fact that a representative of GCEDC appeared doesn't mean that STAMP Sewer Works somehow was required to put up its own officer or put forth people to give its own testimony. It spoke through its counsel in the presentation of the project. It took the public comment. That's the purpose of the public hearing. There's nothing in the EDPL that requires the condemnor themselves present testimony or evidence.
Counsel also argues that the public comment is overwhelmingly opposed to the project. How should we weigh that?
That, Your Honor, number one, there is deference paid, of course, to the conclusion of the entity or the condemnor to the extent there's a basis in the record for it. The fact that the public is opposed is not relevant to the questions that are before this scope of review. It's not unusual that the folks opposing a project are more vociferous in their opposition than are the supporters. What matters is, did the entity that held the condemnation proceeding have the authority to do so, and is it proceeding under statutory authority? Is it a constitutional exercise of that authority? Has there been compliance with SECRA? And here we'll talk about in a second. There's been extensive compliance with SECRA. And will it serve a public use? Not that everybody agrees on that public use, not that everybody loves that public use. Will it serve a public use, and is there a basis in the record for the conclusion that it will? And if you look at each one of those tests here, it's satisfied. The condemnor here is STAMP Sewer Works. They held the public hearing. They are the one issuing the determination and findings under the Transportation Corporations Law. They have that authority. TCL Section 124 gives them that authority. And that's a difference from the IDA issues. Those IDA issues about This is a straw man for the IDA. There's a reason why transportation corporations have authority that IDAs don't. There's no geographical limitation under the Transportation Corporations Law because the type of corporations we're talking about are things like private railroad corporations, gas corporations, telegraph corporations. They're a category that's been carved out. Sewage work corporations are one as well. And the reason for that is they transport things, often across geographic boundaries. So what's required to validly form a transportation corporation, in this case, a sewage works corporation? The statute is very clear. Under 116 and 117, two things, essentially. You need the approval of the town, village, or municipality in which you're going to operate. Notice county is not listed there in TCL 116. And you need consent from the relevant public health department for a sewage corporation of the areas you're going to be in. So here, County of Genesee, Department of Health, and the Orleans County Department of Health. All of those things happened in 2020 for Stamp Sewer Works Corporation. All the approvals were given. It's validly formed under 124. It has the authority to condemn property for the use of the sewage corporation. It doesn't end at the border with Genesee County. It extends into Orleans. There are important safeguards there. Those approvals have to be had. You can't just take and form a transportation corporation and go into any jurisdiction you want and do whatever you want. You have to form a corporation that serves one of those enunciated purposes in the statute. You have to get the approvals that are required by the statute. There's no argument here Stamp Sewer Works complied with those authorizations and those prerequisites for its formation, and it is the condemned NOR. That takes care of the statutory authorization. On the constitutional exercise, there's sort of this public use argument being made by Orleans County. It really comes down to whether Orleans County can go out and manufacture a supposed public use after 8 years sitting on the sidelines while this project progressed through approvals including DEC, DOT, U.S. Fish and Wildlife, despite at least, I think we counted between 16 and 23, somewhere in that range, opportunities for the county to comment, to get involved, dating back to 2016, where the county just didn't. It did nothing for those 8 years. It came in at the last minute after the eminent domain proceeding was already underway, after the public hearing had been scheduled, and acquired 2 purported easements that are supposed to block this project. And those easements say, when you look at the text, you landowner agree that you will not give or deed or agree to give an easement to Stamp Sewer Works. That's what they say. That's not what's happening here. Stamp Sewer Works is not asking them, the landowners, to give us anything. We're not interfering with that restriction. We're taking temporary construction easements over 2 pieces of property. The alleged justification for this by the County of Orleans is that somehow they are protecting the ability of Medina Business Park to develop its own projects in the future, and they may need to discharge into the creek. There has been extensive evidence in this record as part of the SECRA process that nothing that Stamp is doing is going to impair Medina Business Park's ability to do that. It's not going to limit their capacity to do that. There's no interference. So first of all, we submit, and our determination was that these easements are not valid easements because of the nature of the easements, but even if they were, there's no restriction on what's happening here, and there's no conflict, and there's no interference, and the record has nothing to the contrary. So that, we believe, takes care of the prior public use issue. There just isn't a conflict there. Finally, I'll just briefly address the SECRA compliance issue. As we briefed, Stamp Sewer Works is not an agency. The case law is very clear. This type of transportation corporation is not an agency. We're not bound by SECRA. Notwithstanding that, we followed the SECRA process. We were an involved party to the SECRA process done by GCEDC. We took the hard look. We examined it. There's an extensive record on the SECRA side here that goes back years and years and includes right up through the public hearing and beyond. The process was complied with even if we had to. And last but not least, the public use and benefit. I find it hard to believe the argument that's being made is that there's no public use or benefit when, first of all, it ignores the town of Alabama gets 100,000 gallons worth of wastewater treatment out of this situation. Stamp is a priority project for the state. It is the subject and a key component of the semiconductor superhighway New York's trying to build. It's a part of that tech hub designation and was a key component of getting the tech hub destination. It has already generated hundreds of millions of dollars of public and private investment. It has the capacity, once this is done.
I think we have that argument, Counsel.
Jobs that don't end at that border as well, Justice Whalen.
Thank
Unless
you.
there's any questions?
No questions. Thank you, Counsel.
Thank you.
Case 380, Cheruvu MD versus Health Now New York, Inc.
Morning.
1 second, Counsel. Do we have somebody appearing by video, it appears? Yes.
Oh, yeah.
Counsel, can you hear us?
Yes, I can, Your Honor.
And we can hear you loud and clear. Okay, please proceed.
Good morning, may it please the court. One of these days I'd like to get to a jury, but here I just want to get to an answer. And this voluminous motion to dismiss a 3211 motion should be denied for various reasons, but I'm going to start with 3 factual reasons. First, at page 472 of the record, J.P. Kennedy, when this case was dismissed in federal court, made it clear this was a non-criminal disposition in his press release. Those were his words. We determined that a non-criminal disposition was a just result. Remember, we are the Department
And I think he even mentioned, didn't he, Counsel, the fact that some additional information may have come in and may have resulted in the change from a prosecution for a criminal matter to a non-criminal disposition, correct?
And specifically with respect to the mens rea. And that's the second piece of evidence that I think is key is Judge Scretany's decision when he granted the motion to withdraw the plea because there was a mistaken belief that conscious avoidance would be sufficient to prove willfulness, and that's why the judge granted the motion. And so the third piece of evidence was the actual language in the stipulation that resolved the case, the civil forfeiture case, made it clear that the payment that was being made by T3, which was the medical service, that the stipulation was not to be used as an admission of guilt or liability. Under those expressed terms...
In any judicial proceeding.
In any judicial proceeding, like this. So, under those provisions, to rule as a matter of law without discovery or anything that this is not inconsistent with innocence, the double negative, I think was clear error. That's the key from the factual perspective. Now, when you look at the decisions, the 3 decisions that they cite, primarily the Smith-Hunter case from the Court of Appeals, the Cantolino case, and the Martinez case, the reason I still keep arguing about the Supreme Court's decision in Thompson versus Clark is when you compare those decisions, the general basis is the same in the Court of Appeals and the Supreme Court, that the common law rule generally is if the case is terminated so that there's an end to the case, and it can't be brought again, that's sufficient. There are exceptions. And the exceptions that are cited in the case law are misconduct, somebody leaves, runs away, and you can't be prosecuted because you run away. That's the example in the Smith-Hunter case. Compromise, and it's cited in these 3 cases. And mercy. And so, to me, the distinguishing facts in those cases are in both Smith-Hunter and Cantolino, both of those cases, the court reversed motions for summary judgment that were granted. And in the first case, it was whether a 30-30 speedy trial dismissal was sufficient to leave open the I don't want to say the inference of innocence. That's what they were rejecting. They were doing the double negative. And the court ruled it was. And then the second case was whether a dismissal in the interest of justice could be. And that's the case. Both cases started out from malice that was clear. You had, in the first case, there was no malice to begin with, but it was just a situation in a parking lot at a law office. And so this woman got hurt after the end of the thing, and there was a rush to the courthouse to file a trespass charge against her. And the judge said, I'm going to dismiss that. That's nonsense. And he specifically said, I want to make sure that she can go ahead and bring a malicious prosecution.
Mr. Walsh, is the issue, and I think you're on the issue of whether or not there was a compromise, right?
Yeah.
Okay. And is that issue a question of law or a question of fact?
Question of fact.
Why?
Because you have to look at the facts and the actual documents that were used and that criminal case. It was a motion by the government. My client couldn't make a motion to dismiss the case. It had to be a motion by the government. And the stipulation was very clear, and it was in the civil forfeiture case.
You just used the word stipulation.
Yeah, in the civil forfeiture
Sounds like
case.
a compromise.
In a civil forfeiture case. It was not the criminal case. It was clear, it was a non-criminal disposition. And that stipulation, which would result in payments from this T3, would not be used as an admission of guilt or liability. That fits the case law in New York, it fits the federal case law.
Counsel, if we turn to the first element of the malicious prosecution claim, the commencement or continuation of the criminal proceeding by the defendants, here, the way it's framed, working on the task force, giving information to the FBI, if that constitutes that first element, is there a problem discouraging other people working with any municipal authority, federal or state authorities in the future? Because, gee, we could be subject to malicious prosecution if we work with the FBI, provide them evidence.
No, I understand, Your Honor. I understand that concern. I've never seen anything like this. I've researched it. A joint task force where the federal and state prosecutors work with private insurance companies, and they have regular meetings in this joint task force. And just as they state themselves, Blue Cross, they were congratulating their people, their special investigative people, for getting this case into the system and getting it prosecuted. Why? Because they had a seat at the table when they were discussing these things. That's different than somebody just filing a complaint.
Counsel, somebody who files a complaint might have a seat at a table if they're meeting with the FBI in a conference room, right? I mean,
well, sure.
If they're making a complaint and the FBI takes that information and moves forward, what you're saying is this goes well beyond that.
Yes.
This is a special task force that is functioning with and active in the investigation and ultimately in the decision to prosecute.
That's right. And it also rolls into the probable cause question, because the Penry case we cited says that the relevant inquiry is not probable cause at the time of the arrest. The relevant inquiry is probable cause to continue the prosecution, given what was happening here. And our position is, we've alleged...
There's a grand jury indictment here, though. Isn't there a presumption of probable
There is a
cause?
presumption that can be overcome by showing that there's false evidence and a false narrative that was developed to bring this prosecution. A, that this doctor was a bad guy, because when he was in India, other people that worked with him did services, and then he somehow billed for it, and that was wrong. That was one of the key things to make him look bad. The second thing was that there was this dispute about when he saw patients, he would monitor their medication. He had them on very short leashes for the treatment, and also they would do counseling. They didn't have to do counseling with him, but some did. So he himself questioned, how do I bill this? Because the codes don't seem to do it. And he met with them and talked about it. And they sent him an email saying, well, for now, just keep billing it the way you will and work it out later. At the same time, they were going to the U.S. attorney and they were getting ready to prosecute. The reason was, after a while, he said, look, I can't leave this open because I'm just going to build a bigger hole and you're going to take a big bunch of money out of my future billing, so I'm just going to stop. They didn't like that, because then they couldn't get money from him anymore. They couldn't just grab the money. So they used this as the prosecution to charge him with 13 felonies that then got reduced to a misdemeanor, that then got reduced to a non-criminal disposition. His practice was ruined. He spent almost $1 million to defend himself.
Right, but that doesn't that defeat your argument that this is a favorable disposition? It was inextricably intertwined with the civil settlement. It was before the federal judge. There were conferences in front of the federal judge. You made these both sides made these representations, or the U.S. attorney made these representations that this civil settlement was being made to resolve the criminal case. So doesn't the case law basically say that is not a favorable disposition of a criminal case?
No, Your Honor, respectfully, the Smith, Hunter, and Canalino cases where they get that site from,
yeah.
Neither of those cases had any of those facts or any of those things to do.
Well, they don't have the same facts,
They
obviously.
just cite, well, that's one of the exceptions, could be a compromise. The question is, the government said this is a non-criminal disposition. It's a termination at end. They can't come back, and it's not an ACD where if you screw up, you come back, it's conditional. It was unconditional. And they made explicitly clear in the actual document they were dealing with in that civil case to say you can't use this as an admission of liability.
So you envision, go ahead.
Well, I was going to say, so you're saying we should look at this whole issue about whether a civil compromise can be or would not be a favorable disposition in a criminal case as a general matter? Is that what you're saying?
Well, I think you have to look at it under the facts and circumstances of the case, for sure, because...
so you're saying in another set of facts, it potentially could be, but in this case, it's not. For what particular reason?
Because it was very specifically articulated after the plea was allowed to be withdrawn that they had a problem proving mens rea, willfulness. And this doctor, this gentleman, had the unbelievable courage to do what he did when not only did his lawyer want to take the plea, the judge asked him to consult with another lawyer, who I happen to know who that was, I won't say it's not in the record, to make sure he wanted to do that. And then he went forward and the judge said, okay, I'm going to let you do it because I think there was a misunderstanding as to the element of the crime. So yes, under these circumstances, there's at least enough under either the federal standard or the state standard, the new federal standard, to show that it was terminated favorably.
But just on the record that we have before us, I forget which number, document 16, the compromise document is what I'll call it. I know that won't be satisfactory to you, but just for the reference.
I think it's 93, 94.
Thank you. But there was some document entered into between the parties that also resulted in the non-criminal prosecution, right, Mr. Walsh?
Yes.
Okay, so the face of that document would suggest that there was a quid pro quo, that the people, or the government didn't just walk away from the criminal prosecution, but that it was part of an overall package. That seems to be the face of the record. Then, in opposition, the question is whether or not that's an issue of law, issue of fact. You've already indicated that you want to get to a jury and show a question of fact, which, as I understand it, you'd have to basically depose the judge, the acting U.S. attorney, and say, would this have been dropped anyways? What was the nature of the compromise? That's where you have to go to make that argument. But if we look at it under a motion to dismiss, the face of the record seems to say that there was a deal done, a part of which was dismissal of a criminal case or walking away from a criminal case. So I don't know where you get the record where you can say it's a question of fact. Forgive me for being doubtful, but I don't see that in this record.
Well, that's what it seems to say may on a motion, on a 3211 motion, shouldn't even be considered in my mind, Your Honor, respectfully. I think that the fact that you have a terminate, and if you look at the Smith-Hunter case, which I think is, I read it again about 3 times last night, they start with the same premise that the Supreme Court in Thompson versus Clark. When you look at the common law, termination, the case is at an end, that's enough. We do have some exceptions. That's what they say. The Supreme Court says there are no exceptions. We want to have a bright line. We don't want to get into this. Well, let's depose the judge, let's depose everybody else. If it's ended, it's ended. So I think where this case goes, that's why I still think Thompson versus Clark is important when the Court of Appeals, if it ever got the case, I hope I don't get this case, I hope we can go back. I'd like to go the other way, back to Buffalo. So I don't think you can do it on this record. What happened, and that deals with a lot of the other stuff, and exactly how much influence there was because of this joint task force and how much they were pushing this. I don't know all of those facts because I haven't had any discovery. I have there was a case called Zwick that was cited by both sides. It's a Western District of New York case, and Justice Genesee, he actually, after Thompson versus Clark, reversed himself and said both state and federal cases are going to go to trial. So that's where I think it's a question of fact.
Counsel, you should begin to wrap up.
Okay. On the fraud case, the argument is that they have to make the fraud allegations. Look, he was told to keep billing it the way he was, and he thought he would be fine. That's where the fraud claim comes in. And I think, given all the circumstances, under the elements in the case law, we've at least established enough to get past the 3211 motion on the other causes of action for emotional distress.
Thank you, Counsel.
Good morning, Your Honors. Both judges who have dealt with the state law claims here have decided that the plaintiff didn't meet any, let alone, or didn't meet a single let alone any of the elements of the malicious prosecution claim. And I'm going to start by pointing out what Justice Curran pointed out, is that at page 87 of the record is the government's notice regarding dismissal. And that is the document on which the criminal case was resolved. Not the civil case, but the criminal case. And what that document specifically says, and it's part of the record, is that the government stated that at a status conference on August 14th, 2019, they advised that they were attempting to resolve this case by way of a non-prosecution agreement between the government and the business through which Dr. Cheruvu practiced medicine. After continuing to negotiate in good faith, the parties have reached a resolution and have entered a non-prosecution and compliance agreement separate, as well as a stipulation in the parallel civil forfeiture case. In light of those agreements, dismissing the superseding indictment is a sound use of prosecutorial resources. This was a compromise in every sense of the word. He gave up $100,000. He also got releases, or he gave releases to law enforcement and the prosecutors not to pursue civil charges with respect to the forfeiture. And in exchange for that, they dropped the prosecution. And this court made clear in Weaver that a compromise resulting in dismissal of criminal charges does not satisfy the element of successful termination in favor of the plaintiff. That is the law in New York State. Thompson is not the law in New York State, and you cannot possibly look at this document and this record and say that there wasn't a compromise. He gave up $100,000 to get rid of the criminal prosecution. That is not disputed. So, Your Honor, I think it's really clear on this record that there's not a question of fact here. And if you were going to get into, okay, what does it mean to continue to negotiate, you would have to depose all of the prosecutors, the defense attorneys. And that's not necessary, given this record and the clear dictates of this document. I would also want to point out, Your Honor, with respect to the commencement issue, the idea that the defendants had some undue influence over the prosecution here, there's a lot of talk about that in their brief, but if you look at the facts that are pled, and there's a lot of words in this complaint, but it doesn't say a lot. If you look at the facts that are pled and you look at the timeline here, what the timeline is, assuming what the plaintiff says is true, is that in December of 2011, the defendants brought the case to the task force group. That's all it says in the complaint. Nothing in 2012. Absolutely no contact between any of the defendants and any law enforcement or any of the prosecutors. The complaint then says in 2013, the FBI and the New York State Attorney General Medicaid Fraud Unit conducts an independent raid. No allegation that any of the defendants were involved in that raid, had anything to do with the raid, no allegation that they were present at the raid. Then in December of 2013, Susan Schultz.
Counsel, I'm going to interrupt you for just a second and get you off the reading of the complaint, which we have before us. But isn't there, counsel made an argument that there are emails in the record that are fairly, you can fairly infer from them that there's congratulatory emails within the task force talking about how they were instrumental in moving this forward. Could you address that? And
well,
isn't that a concern?
Well, are they appropriate? I don't know, but they do not suffice to create a cause of action here where none otherwise lies. They were happy about Dr. Cheruvu being indicted, certainly. The task force works with the FBI, as Justice Nowak pointed out. You want to have that to weed out fraud in healthcare. How else would the FBI do it, or the Attorney General, or the U.S. Attorney do it? You want that cooperation, and when you have some level of cooperation, there's going to be an email or somebody saying, hey, good job, nice work, we're glad, we're happy we got this guy off the street. But what I was going to point out with the timeline, Your Honor, is that the only involvement of the defendants prior to the arrest of Dr. Cheruvu, and the arrest was in May of 2014, was the allegation that they brought it to the task force. There's no other allegations of wrongdoing, and there's not even an allegation that there was any contact between the defendants and any prosecutor. And that arrest was pursuant to a federal complaint, which means that it was brought to a magistrate who decided that there was probable cause for the arrest. So right there you have the first level of probable cause sort of backstop here. And that was a federal magistrate who decided that.
You're getting to the presumption here, right? We have a grand jury indictment also.
There's two presumptions here. One is that prosecutors act independently, and there's nothing in the complaint to indicate that that wasn't the case here. Two is you have a presumption of probable cause. And here you have a presumption of probable cause because you have a magistrate that signed a federal arrest warrant. You have the first federal indictment, which was before there was any allegation of any false testimony or any wrongful conduct at all. You have a federal indictment. You then have a superseding indictment. Then you have even a state grand jury indictment. And there's no allegation that the state grand jury indictment was rife with fraud or there was any false testimony. So you have all of this probable cause out there, which...
But the facts play out, don't they, in this case? And just correct me if I'm wrong, the record seems to reveal, and the judge vacated the plea based upon information that came along later. Isn't it a fair argument that that information should have been made available to the grand jury? And if so, would that presumption have been rebutted?
That would be, that may very well be possible, but that would be a claim against the government, which he waived, not against the defendants. If the government didn't turn over exculpatory information, that's on them. And I think that that really boils down to where this is that the plaintiff is angry about this prosecution. Maybe understandably so. But that anger is displaced against the defendants here, whereas it was the FBI and the prosecuting attorneys that didn't turn over whatever information he's talking about. It wasn't on us. And there's no claim here that Health Now didn't comply with a subpoena or any of the defendants didn't comply with a criminal subpoena. All the complaint says is that during the trial they received exculpatory information. The judge said, why wasn't this turned over? And we are where we are.
Thank you, counsel.
Thank you, Your Honor.
Good morning. Thank you.
Proceed, counsel.
On behalf of the two independent health respondents, I'll say that the substantive arguments made by Mr. McLaren, I think, apply collectively to all the respondents. There's no point or need for me to repeat or re-argue what he did substantively.
Thank you.
The one matter that I would raise that I think is specific to independent health is that I think it was clear from the written brief by the appellant, and I think even more clear based upon the argument today, is that the plaintiff's claim, I think, is against what's been pled, and I think what he's pursuing is claims against the Health Now entity. There are all of the allegations, all of the factual allegations of this complaint about any conduct in support of any of the remaining causes of action are specific to and limited to conduct of one entity here, the congratulatory emails, to the extent that there was alleged fraudulent testimony or false testimony. All of it's specific to one entity here. So in addition to the substantive grounds that I think Mr. McLaren argued very articulately, there is an additional basis for this court to uphold the dismissal of the complaint specific to independent health.
Thank you, counsel. Mr. Feinstein? You're on mute, sir.
Excuse me, Your Honor.
Proceed.
Thank you, Your Honor. I will also keep my comments very short, and I certainly believe that Mr. McLaren presented the position of all defendants very ably. I think the complaint here is, in terms of specific factual allegations, is remarkably thin, while also dealing with malicious prosecution, where the Court of Appeals has made clear that the elements of stringent requirements, and there's obviously strong public policy reasons for having stringent requirements. I will also point out, I am unaware of any New York case or otherwise, and certainly Mr. Walsh has cited none, where a settlement has been treated as a favorable outcome. And lastly, I will point out that, as far as I can tell, the only specific allegation, factual allegation, against my client, Univera. It's a benign statement made some 4 years after the plaintiff's arrest. So, I mean, there's certainly no basis for the complaint to proceed against any of the defendants, and certainly not against my client.
Thank you, counsel.
See, I'm not on the,
Oh.
should I see if they're,
Yeah.
I have to climb.
Well, yeah, don't, let's not worry about it. Yeah.
I'll let you know.
Let me just, before we call the next case, Mike, we're having a problem with the monitor with Judge Greenwood. And if there's a way to get it fixed, that'd be great. But we're going to proceed with argument. I trust that he'll be heard. Let me know if he won't be heard, if he has questions. Case 381, the matter of Dean Taylor versus City of Buffalo.
Good afternoon, Your Honors. Ryan Solani, Assistant Corporation Counsel on behalf of the appellants. I just want to start, and I'll do my best to be brief because I believe our record is very thorough and our briefs are quite voluminous. But I'll start with an issue that I believe the Supreme Court just undoubtedly got wrong, and that's the question of finding a probable cause or arguable probable cause in this case. We detail that in our brief extensively, but I would just like to add that many officers were involved in the arrest of the respondent here, and even more officers witnessed the arrest. And in their witness statements, which are provided in the record, none of them had any issue with the finding of probable cause for his arrest, or any issue with the amount of force that was used to arrest the respondent, which I'll get to in just a moment. And I'll just note that in response to this issue, which I believe we carried our burden at summary judgment on the issue of whether probable cause existed. In response, the respondent only stated that the arrest was ultimately determined to be unlawful, which is patently false. The charges were dismissed by the criminal court, but they were only dismissed because of deficiencies with the accusatory instrument. And due to that, the nature of the dismissal, they can never have gotten to the merits of the arrest or a finding of whether or not probable cause existed. As a result, the cause of action for false arrest should have been dismissed as probable cause existing is an absolute defense. Similarly, it's a defense to the cause of action for assault, battery, and public battery, provided that the amount of force used was reasonable, which I'll get to now. On the question of excessive force, while it is typically a question for a jury, I believe here, given the body camera footage that we have and the footage from the respondent itself, it can't be argued that the amount of force used was objectively reasonable pursuant to the Fourth Amendment, given that the respondent is clearly seen on the video actively resisting the officers up to the point where he is handcuffed, where he stops resisting, and at that point, the officer's use of force ceases.
Is it your position that the body cam video captures everything?
I believe so. You have to sort of look between the videos to get the full picture. There is one point where I believe it's Officer Moriarty, his video falls on the ground, but at that point you can look over at Officer Burgett's video, which continues to show the arrest being taken place, and I believe we offered Lieutenant DeLong or Champion, I'm sorry, there's a lot of officers involved, I might be confusing them, but in the third video you can also see sort of from further away the arrest taking place. So by combining all of them together, I think you can get a clear view of what occurred during the arrest, and you can clearly see the respondent's active resistance to the officer's actions. So, given that, there cannot be a question of fact as to whether the amount of force was excessive. He was resisting. Once he stopped resisting, the amount of force ceased. It was objectively reasonable under the the Fourth Amendment, and therefore the excessive force, assault, battery, and public battery cause of action should have been dismissed. And to draw a distinction on that point, respondent does attempt to look at the contradictory deposition testimony in this case. And while that usually would create a question of fact, just again, the body camera footage removes any question of fact of what did or didn't occur here. And I believe we should follow that.
The reason I asked about the body cam footage is that I didn't see Officer Moriarty punching.
Correct.
I didn't see it in the body cam. Officer Moriarty testified that he did.
Right.
So that's my question. Maybe it doesn't show everything because what the officer admitted he did, I can't see on the video. Do you think that we should just disregard Officer Moriarty's admission that he punched him in the face?
Honestly, Your Honor, I believe that we should, because it can't be questioned what is shown in the video. We have a clear view of what happened in the video, and as you pointed out, Officer Moriarty may have been mistaken during his deposition, but he clearly did not ever punch the respondent in the head. And in fact, no officers at any point during the arrest punched the respondent in the head.
So based upon what we see in the video, your argument is it just becomes a matter of law and not a question of fact?
Correct.
In spite of the contradictory testimony?
Correct.
We'll take a look at that,
The video shows
Counsel.
what it shows.
We'll take a look at that.
Okay.
Anything further?
I'd just like to touch on the 1983 claims against the officers. I'll just briefly say, because the amount of force wasn't excessive, there was no constitutional violation, so the 1983 claim against the officers should have been dismissed. And I would just like to highlight against the 1983 claim against the city, the Southern District of New York's analysis in Calderon v. City of New York, and that's a case pointed out in respondents' papers, and just encourage the court to follow a similar analysis as there. The examples provided by the respondent, out of all of them, there was only one civil judgment held against a single officer that resulted in a 1-year probation. All the rest of them, there was no judgment against the city. And the oldest suit that they point out in their examples dates back to just 2019, which fails to show any custom or practice of the police department using excessive force.
Did the city meet its burden on the 1983 claim as far as proper training of the officers?
Right. In the evidence in the record,
Right.
sure. There is no accusation that there was any deficiency in the training of the officers. I believe we provided training records. I might be mistaken on that, but the record might have training records. The officers have been trained. They regularly do training with the city.
But it's the city's burden, you would agree?
Right, and there's no evidence contrary to that they have been trained, and the respondent doesn't argue that there was any deficiency with the training. So I believe we did carry our burden on that issue as well through their training records that are, I believe they're part of the record.
Very good. Thank you, Counsel.
Thank you.
Hi, Your Honors. Blake Zaccanino on behalf of the plaintiff. These are big briefs, so I'll do my best to also be brief. Judges, the first issue that I wanted to point out was, Judge Nowak, I agree with you that the videos don't show everything, and I think the conflicting testimony in the record is important, and that makes it relevant, which we believe in itself creates an issue of fact. I think it's important here that the city's own department determined that the plaintiff's arrest was unlawful and that he was lawfully on the corner filming people in public, and that he should not have been arrested in that circumstance. And also, all of his charges were dismissed as facially insufficient, and it's my understanding that the charges were sealed per CPL 16050, I believe it is, which it's my understanding that when that happens, it means that the disposition was in favor of the defendant. Regarding this, the argument of arguable probable cause, based on my reading of the case, it's my understanding that that argument only applies to false arrest claims alone and not to any of the other claims that we brought. But again, going back to the fact that the officers were disciplined for arresting the plaintiff, and that all of his charges were dismissed, we feel that at least creates an issue of fact that there was not probable cause. On this issue of excessive force, you know, in looking at the videos, the plaintiff is on the corner filming. It appears that the officers come over, ask him to move. He answers, "Why do I have to move?" And then it seems like he goes from zero to 60 in seconds and throws him to the ground. And then when, I think it was either Officer Bridget or Moriarty's body cam fell, you can hear what sounds like punches, then also with the one officer's admission that he hit the plaintiff.
The plaintiff doesn't have any recollection of what happens after there's a conflict.
Yes, Your Honor. I think he testified that it was lights out or something. I think that's what he said. Right. And the last point I'll make is on the issue of Monell and a bad policy, custom, and practice. We cite to 27 prior similar incidents that include a UB Law study and Cornell study that found, after doing research, that the City of Buffalo had a pattern and practice of using excessive force and unlawfully arresting people. And we also cited the city's own records showing I think the one record was the top 10% of officers that had excessive force complaints against them. So we feel that all of that evidence shows that there was at least notice and knowledge of an ongoing issue with the city that would raise an issue of fact. And the last point I'll make is on the issue of, you know, like whether or not we made individual claims against the officers. Looking at the course of proceedings test, we feel that we meet every element on that to give the individual officers notice that they're being sued in their individual capacities. That include the officers being sued individually, also naming the city, the fact that qualified immunity was raised by defendants, that we were asking for punitive damages, that we alleged intentional torts, which are normally those that are meant for individuals and not for the government entity. And lastly, we included a John Doe placeholder that was meant for the other individual defendants that specifically said the possible future individual defendants were being sued in their individual and official capacities, which would lead them to have notice of that. So I appreciate your time. If you have any questions,
So
please.
you're not conceding that you're not entitled to punitive damages against the city, right?
No.
You're not conceding that?
No.
Okay. Thank you.
Thank you, Counsel.
Thank you.
Case number 382, Nirbas versus 600 Cayuga Road. Presiding Justice Whalen is recused. Go ahead, Counsel.
Good afternoon. May it please the court, Andrew Kovalewski on behalf of third-party defendant Plastic Bottles, Inc. This appeal stems from a denial of summary judgment in favor of my client. In fact, the court granted summary judgment in favor.
Both parties moved for summary judgment.
Correct, Your Honor.
So they seem to agree that this is a question of law.
Yes, and I would agree that it is a question of law for this court to decide. It's undisputed where this fall occurred. It's 10 feet from the door of the warehouse in the parking lot. The facts of who was responsible for maintaining that area under the lease agreement are undisputed. The landlord, 600 Cayuga Drive, or Road, I believe, is the entity who's responsible for maintaining the parking lot where plaintiff fell.
Isn't that sort of subject to dispute?
Well, there's a dispute about whether my client also shoveled the area to gain access to another door. But that is not whether there's a contractual duty or a contractual obligation to maintain that area. And if what we have here is a situation under the indemnification clause, which I argue was invalid, and I'll get into that in a moment, but it says that my clients have to arise out of the acts or omissions of my clients. Well, under the lease, my clients...
Growing out of, right, counsel?
Growing out of, exactly.
And the question then, and I don't mean to steal your thunder here, but as I understand the way Supreme Court decided, it said under the case law, growing out of could include this fact pattern, and therefore the indemnification clause would be triggered, so to speak.
That's correct. That was the trial court's decision. I have two separate arguments when it comes to the contractual indemnification issue. The first argument is that this provision violates the general obligations law, and my brief is very thorough for the reasons why it does so.
Assuming it's triggered.
Assuming it's triggered. If it is triggered, it would violate the general obligations law. But the language of the provision itself shows that it wasn't triggered in this situation. And I refer the court to the Burbank case, which is cited in my brief, which is exactly factually on point. It's a Westchester County case involving this language in the indemnification provision. And in the Burbank case, there was an employee. Here we have an employee, just the same. So it was an employee walking across the parking lot who falls. The court in the Burbank said that indemnification provision was not triggered based on those facts. And this is exactly the same situation we have here. The indemnification language is the same, the facts of the accident is the same, and so the indemnification provision was not triggered in this case. And the court should follow that Burbank decision because it was a well-reasoned decision, and I think the court should take that into account.
So we should read that case and then compare it to the cases Supreme Court cite and otherwise cited in the brief on the triggering question. And then that takes us, I think, to the general obligation laws argument, right?
That's correct. If there's any case to look at in the briefs that are submitted, it's the Burbank case. But for the general obligations law argument, I'll be brief on that. The Fourth Department in graphics art supply held that there must be a mutual obligation to procure insurance in order to get around the prohibition of having a party seeking indemnification for someone else's negligence.
How that stacks up against Great Northern is sort of a question, perhaps, in some people's mind, but certainly there has to be insurance to work around it, correct?
There has to be insurance, and I think the graphics art supply says there must be a bilateral obligation to procure insurance. And the graphic art supply case has continued to be cited after Great Northern. So it is still good law. It is still law that is in force today. In the Great Northern case, and I should point this out while we're on the topic of Great Northern, in Great Northern, where my opponent cites the law language from there in their brief, the Great Northern case involved a situation where both parties obtained insurance on the property. It was in that case, the landlord and the tenant had insurance on the property under the lease. The lease provisions required it.
This whole, you've used the phrase, I think, bilateral obligation. You said mutual obligation. And I'm looking at the block quote you have on pages 5, 6 of your brief, the reply brief on graphic art supply. They don't say obligation, they say participation. Mutual obligation, I would agree with you, falls under Wagner and maybe some of the Second Department cases that you cite. But this whole notion of not obligation to each purchase insurance, but bilateral participation in the contract we have here, which is we both agree, we both understand, we both wrote in, I don't know who wrote it in, but somebody wrote it in on this contract that there should be the purchase of insurance on behalf of the owner, right? Why do you say that we have no evidence here of bilateral participation like they found in graphic art supply, whereas here, why isn't that an issue of fact?
So in the lease agreement that we have here, there is only one sentence that is handwritten regarding the purchase of insurance. And it states that PBI is to, well, there's an issue about who is required to obtain insurance, but it only says one party is to obtain insurance. In the Great Northern case, the lease agreement in that case required both parties to procure insurance. It's a factually distinct situation where, in this case, the lease only requires one party to procure insurance, and in Great Northern, it requires both parties to procure insurance.
But, Counselor, is there another problem here that you're alluding to, that one of the problems here is the lease did not exclude the landlord's own, under the insurance provision, excluding the landlord's own negligence from that requirement?
Yes. The actual indemnification provision, and I think I believe it's the Wagner case from the Fourth Department has held that when you have a indemnification provision that says any and all liability, whether caused in whole or in part by that person, you're trying to shift your entire liability to another party. In this case, the landlord is trying to shift all negligence to the tenant, which is my client. And that is why it violates the general obligations law. That triggers the analysis of the general obligations law.
So if they had excluded it out, it would have been okay in your view, correct?
Correct. If the language was completely different in the indemnification provision, then we wouldn't have to go through the general obligations law analysis. But here, it's clear that it is a situation where we have to go through the general obligations law analysis because of the language of the indemnification
I think
provision.
they can lower the standard too. Can't they make it gross negligence if they want, and that still complies with the general obligation? I mean, it doesn't really matter for this case.
I can't comment on the gross negligence comment, Your Honor.
Okay.
Counselor, just the way I'm trying to organize it in my head, so we're already beyond, for the sake of argument now, the triggering thing. Now we're under the contractual indemnification clause. The parties seem to agree, and I'm going to ask this for both sides, that this clause should be or is read to exempt the landlord for liability. That brings it within the void provision of the general obligations law. So if, as I understand the arguments of the party, but for the provision of insurance in the lease, this indemnification clause would be void. Am I close to having the argument correct on that?
You are correct on that, and the distinction, the argument here is about whether the one sentence, handwritten sentence about insurance, is that sufficient to get around the general obligations law?
And your client testified in his affidavit that the landlord put that provision in the lease, so that, I don't think there's any question about a meeting of the minds. No one's saying that wasn't a meeting of the minds, and it wasn't put in the agreement by both people agreeing. So that's bilateral, I think. So, and your client then went out and got insurance, and according to his deposition testimony, thinks he still has the landlord as an additional insured. And then the other side pointed out the provision in the policy that seems to say the owner is an insured under the policy. So in terms of the bilateral, mutually agreed upon matter in the agreement, would you agree that the evidence, if we look at it most favorably to the other side, which we must on your summary judgment motion, we should presume that in fact there was insurance?
So I just want to understand the question. The bilateral or mutual obligation, I'm going to, whatever the terminology in the graphic art supply decision, requires that both parties obtain insurance, their own insurance on the property. That is my reading of the case, and I think that's the way that case has been interpreted. That did not occur here. So my argument is because each party did not obtain their own insurance pursuant to the lease on that property, that it would violate the graphic art supply case.
Go ahead, please, you first.
If you have two sophisticated contracting parties, and they both agree, no, you get the insurance, I don't need to, and they agree to that, and they put it in writing, you're saying that it's still void, because no, you both have to acquire it. As opposed to bilateral participation, where you essentially have a real agreement, you don't have a situation where a landlord's sneaking something in, sneaking a requirement in that the tenant may not even be aware of.
Yeah, our position, and I think what the case law says, is that both parties need to obtain insurance on the property.
The Second Department cases that you rely so heavily on, and I'm going to mispronounce it, but you know which one I'm talking about, the Hazanova case, the NA case, those are the two primary ones. They don't say that both parties have to do it. They say something different that's also favorable to you. That is that you have to get insurance, and the landlord has to agree to be limited to the limits of the policy. That seems to contradict directly the idea that both parties must get insurance, because those cases look solely at the coverage provided by the tenant and the amount thereof. Am I right?
Well, I had three different sub-arguments why this indemnification provision violates the general obligations law. I don't think those cases are mutually exclusive, but certainly if this court were to hold that it violates those Second Department cases.
You don't care how we get there. Lawyers just want to win.
I care about the destination instead of the journey. So,
but the Second Department cases you rely on very heavily, and they have some favorable language in there, and I'm not so sure that your opponent has even addressed those, and we'll talk about those in a second. But, you know, the other thing is the footnote 4 in Great Northern talked about how not having it limited to the amount of the coverage. is not fatal, if you recall that language in footnote 4 and Great Northern. So, very honestly, counsel, one of the things I am struggling with is it seems like there might be questions of fact here. What does that provision about getting insurance mean? Was there insurance? Things of that nature. But both parties have clearly driven a path that says we win as a matter of law, and that's all we seek on appeal. That's clearly how I read your brief. Do I have that right? That your both conclusion sections in the appellate's brief and the reply brief quite clearly says we get summary judgment and they don't.
Yes, Your Honor, that is absolutely correct.
Anything further on your end then?
I will refer to my papers on the other issues. The common law indemnification claim has been withdrawn by the third-party plaintiff, and failure to procure insurance, I think that my brief speaks to that, and unless you have any questions on that issue.
On that point, I forgot about that, the failure to procure insurance. The court was silent on that subject, so we deem that denied, correct?
That would be my understanding.
Okay. And has the other side briefed that to your knowledge about the failure to procure insurance?
Yes, that was, I moved for summary judgment on that issue. My opponent has briefed that and has opposed that.
So what there we could find there's a question of fact whether or not that was done. But in moving for summary judgment on the other issue, I think maybe we do have to assume that in fact insurance existed, as your client testified to during his deposition. We'll have to take a look at that.
Okay, thank you, Your Honor. Thank you.
May it please the court, Nancy Long, on behalf of 600 Cayuga Road. I think there's a couple things I want to address. First, I think it's important to note that the indemnification agreement in this lease only runs in favor of my client, 600 Cayuga Road. So as far as the insurance obligation, I think it's clear that, they were the ones that needed to have plastic bottles get the insurance to protect them. It's not a mutual where they were both agreeing to indemnify each other. So therefore, it doesn't make sense that there would need to be the mutual insurance requirements for both of them to have the insurance, because the provision only protected 600 Cayuga. With regard to being indemnified for their own negligence, this is a commercial lease. The case law is clear on that. With regard to a commercial lease, a party can be indemnified for its own negligence as long as the two parties agreed to it. They're two sophisticated parties entering into this lease agreement. And I think it was brought up by Justice Curran, there does have to be that insurance procurement requirement so that it is not void by the general obligations law.
Just don't lose your train of thought. But would you agree if there was no insurance provision here, this would be void?
I would concede that, yes. But there is an insurance procurement provision. It was handwritten into the lease. And based on the case law and contract interpretation law, that has to be assumed to be the latter understanding of the parties. It was handwritten in there. There is, contrary to my opponent's argument that it's unclear who was required to get the insurance, it's clear from the owner's testimony, George Tahar, that they understood their obligation to get insurance. He acknowledged that he got insurance. He never asked his insurance company to take 600 Cayuga Road off of his policy. And in fact, there is insurance covering this loss. It's our position that there is. So I don't think there's any question that there was a meeting of the minds, that Plastic Bottles understood its obligation, that it was to indemnify 600 Cayuga, and that it was also required to get insurance to protect it for any loss. With respect to what it was supposed to cover, that is clear as well based on the lease agreement language. For any matter or thing growing out of the occupation of the demised premises or of the streets, sidewalks, or vaults adjacent thereto. And as it was pointed out that the court relied on that language, the growing out of language. There are numerous cases we cited in our brief. The Bailey versus Macy's case, the Amato, a Court of Appeals case.
Right, but unfortunately they left out parking lot.
But it doesn't matter. They talked about common areas where people were injured but were there for the sole purpose of that tenant's business, which is the point here.
Parking lot's a pretty significant area, so to leave that out is kind of a large,
It was a parking lot in Campisi. The Campisi case is a second department case where the individual was injured going to the supermarket in a common area of the parking lot, and the court held that the tenant had to indemnify the landlord for that loss.
Okay, now just to be clear, in the record, your client did have general insurance for the building, correct?
Correct.
Okay, and this was just to indemnify them by this subtenant, basically.
Typical lease,
Right.
you know, where they're asking for the tenant to protect them if there's a loss growing out of the occupation of the premises. The plaintiff here was at the business for no purpose other than to go to work. He was walking into work at the time. As far as further triggers of this, PBI, or plastic bottles, acknowledged that they were maintaining this area where this individual fell. They had been shoveling and salting it for almost 20 years.
Ms. Long, let me just take you real quick back to the cases. I want to make sure I ask you this,
Sure.
because I brought it up with the other side. And I know it's off the triggering issue, and if you need to go back to that, that's fine. But you didn't really address the cases I mentioned a few minutes ago, the Hazanava case, the NA case, that have that language about, well, you've got to limit the lessor's recovery to the insurance proceeds. There's no mention of the amount of insurance in the lease here. We know from the record that it appears to be a $5 million overall umbrella with a $1 million, I think, per instance, something like that. How do you address those cases? I mean, we're way beyond the statute, first of all. The Court of Appeals took us there in Hoagland years ago. You know, here's the statute, it says it's void. No, but if you got insurance, it's not. Now there's Second Department cases saying, oh, you not only have to have insurance, you have to limit the landlord's recovery against the tenant to the amount of the coverage. How do you reconcile that? I mean, is that the law? I don't know if we've
I don't
ever
know
said
that I agree with that, because Great Northern doesn't require that. I mean, the Court of Appeals has not required that it be limited to the amount of the insurance coverage. So, I mean, my position is the Court of Appeals has not held that that is the law in the state, that it would have to be limited. So I don't think that alone would void it under the general obligations law.
Anything further you want to go back to, or else?
No, I think I'll rest on my papers for the remainder unless the court has any questions. I think, it's clear that there was the trigger here, that this is not violative of the general obligations law, that the provision stands that there was a meeting of the minds with the intent for plastic bottles to protect 600 Kuga for incidents or accidents arising out of the use of the premises.
Weird, you heard that noise, didn't you?
I did, yeah.
It was like when a video game stopped.
I know.